state that on 2/12/2025 at about 9:30 a.m., I took my 3-year-old son, Huzaifa Akhtar, who was bitten by dog, went to Raj Medical Hall of the above named accused persons as per instructions of the doctors of Dhing FRU, and brought the injection. And while I was coming to FRU, accused persons forcefully injected my son, and after 10 minutes of injection, my son succumbed to death. Be it mentioned here that on 29/11/2025, I went to Dhing FRU for the treatment of dog bite, and on that day, the doctor gave one injection. So first injection was given by Dhing FRU, Lordship, and advised to take another injection on 2/12/2025. And hence I came to Dhing FRU today. As the injection was not available in Dhing FRU, so they asked me to purchase the injection from the pharmacy and to bring the same to Dhing FRU. But the accused persons forcefully pushed the injection even though we resisted, thereby causing death of my son. Now here my role is that, Lordship, I am accused number 1, that is owner of that medical hall. Now your Lordship may kindly turn to page 23. Page 23, this is the seizure list. Serial number 2, your Lordship will get that CCTV footage is already seized by the police. I was not present at that moment when that was injected in the body of that boy, Lordship. That therefore that CCTV footage is there. Now why I am saying so, Lordship will find that another seizure list is there, page 25. From first line, your Lordship will get, I so and so, Dhing PS do hereby seize the below descriptive documents on being produced by Bijoy Krishna De. So that is the petitioner before your Lordship. So from my possession, these documents were seized. I was not arrested because CCTV footage already shows that I was not present at that moment. And in fact, now if your Lordship turns to
the story is that the allegation is that his second injection was purchased from the petitioner's shop. Thereafter, after injection, he died.
He died. That is the allegation. First injection was given by Dhing FRU. And in this case, Lordship, paragraph
From the
6
pharmacy and to bring the same, but the accused persons forcefully pushed the injection.
Yes.
The accused persons forcefully push the injection means because this person they are not the person who injected, isn't it?
This person, present petitioner, knows the person who injected.
But the accused persons forcefully injected, pushed the injection,
Pushed the-
even though we resisted.
Yes.
This I have not understood actually.
Uh,
But this part I have not understood.
Page
What does
21
it
is the
say?
vernacular, Lordship.
Vernacular say? What does it say?
Page 21.
So probably they are indicating that it was probably contaminated or something.
Probably that is there. And already these vaccines were seized, Lordship, that in fact, page 23, Lordship may kindly see that expiry date is there. It is within time, Lordship. Page 23, your Lordship will find. Serial number 1.
I've seen this.
Lordship. That expiry date is of 3/2026. That is valid till March, Lordship. And in fact, in the present case,
What
Lordship,
is the vernacular equivalent of this?
page
What does
21.
it say?
Page 21.
Because the injection was pushed in Dhing PRO, right?
First one was given in Dhing PRO.
The second one in pharmacy.
Second one in pharmacy.
When he bought to the injection, then he
because
was
that medicine was not available in Dhing FRU, so he was referred to
The pharmacy.
Pharmacy.
Take the injection there.
Yes.
But once it was
And
pushed,
according
he
to your
died.
prescription, it was given, Lordship. And if Lordship is these medicines are given, nobody will die within 10 minutes. There may be some other reasons also.
No, there was some
Yes.
violent reaction maybe.
Lordship.
Anyway, what do you say?
Lordship, and saying page 23, Lordship, that serial number 1, that vaccines were seized, that the expiry date is on March 2026. That is there. And therefore, Lordship, police never arrested the present petitioner, Lordship, and documents were also seized from him. Then, Lordship, 35(3) notice was given to him. He appeared and cooperated in the investigation also. But police is repeatedly calling him to the police station, therefore he has filed the present case. That 35(3) notice, Lordship, I could not annex. I received it subsequently, just I am handing over to your Lordship. But I have stated in my paragraph 6 all the dates when I received the notice, when I appeared before the investigating officer. That copy I have handed over.
Statement has been recorded already.
Already recorded, Lordship. The only that I have given that notice to your lordship. Dada. The 35-3 notice was given on 17/12/2025, directing him to appear on 18/12.
Forcefully injection giving, I don't, spot is slightly confusing.
Only he is the owner of the pharmacy.
And I have enclosed all the documents from Annexure 1 also.
He's the owner of the pharmacy.
Owner of the farm.
As per his submission, he was not present at the time of the when he was injected.
Anyway, A. Ahmed, learned counsel for the petitioner and D.P. Goswami. 482, Dhing PS case number 292 of 25. 105 is what?
Culpable.
Oh,
probably
not
that
a
would not count.
That could be knowledge of the, yes, if it is, they know that it is a fake,
Lordship.
then maybe.
But if it is medical negligence, then one inquiry is
Then it
required.
will not be. The FIR was lodged by the father of the victim boy. FIR on
2/12/25.
2/12/2025 with the allegations that on 2/12/2025 he had taken his son, his minor son, to Raj Medical Hall, of which the present petitioner is the owner, stated to be the owner, as per the instructions of the Dhing PRO, and bought an injection for dog bite. And while he was coming to the FRU, the accused persons named in the FIR forcefully injected his son, and after 10 minutes, his son died. He submitted that the present petitioner is the owner of the said Raj Medical and he was not present at the time of the incident. It is stated that he had already appeared before the IO, complying with the notice and assisted in seizure of the medicines, the rabies vaccine/medicine, and with the expiry date indicated as 3/03 of 2026. Full stop. Call for the case diary from the concerned police station. However, in the interim, in the event of arrest of the petitioner in connection with this case, he shall be allowed to go on bail of rupees so and so 25,000 with one security of the like arresting authority, and subject to the condition, he will cooperate with the investigation. His statement has already been recorded,
Already
right? So does he need to come and go again?
After in protection of
And he shall not hamper or tamper with evidence. If necessary, he shall, if necessary on the part of the IO, he shall make himself available for examination again. This is the matter of 27. I'll keep this one.
Lordship.
Yeah, unfortunate. Maybe. He died.
May I please?
3 and 4. Connected. 3 and 4 are connected.
My lord, page 27 is the FIR, my lord.
3 and 4 same, no?
Page 27 is the FIR. Here, specific allegation, my lord, against FIR named 4 accused. The petitioner is not FIR named, my lord. The allegation is that on credit, 2 vehicles was sold and that was not paid. And subsequently, they denied to pay. This is the allegation, 4 accused persons named in the FIR. The present petitioner of your lordship, my lord, he is not named in the FIR. But he has been issued with 35(3) notice, my lord. Only because of the fact, my lord, the present your lordship will find 35(3) notice at page 34.
1830.
My lord got it.
Here, my lord, the petitioner's elder brother running a used car showroom, my lord.
Hmm.
His name is Ashraful. I have annexed all document. He has income tax, registration, everything is there from page 9 onwards, my lord. Your lordship will find from page 9 onwards. This is 9 is the trade license.
Hmm.
The lordship got it, my lord. In the name of Ashraful, the elder brother of the petitioner, my lord. All these things are, my lord, income tax return,
Used car dealer.
Uh,
Used car.
used car.
dealer.
My lord, he is also that Ashraful, my lord. He was also issued with notice, my lord, 35 notice. And he approves the jurisdictional session code, my lord. And the A to this.
And he was granted bail.
He was granted interim bail, my lord. So I am prayed, my lord, I will appear before the IO, my lord. I may be protected, my lord. A specific allegation against FIR name, only one accused. They were, they are known to each other. They are the interim bail granted.
Woodden and DP Goswami, 482 bail application. Disney PS case number 138 of 2025. The gist of the allegations in the FIR lodged by one Anamul Haq on 1/11/2025 is that on 10/9/2025, the four accused persons named therein purchased took away two vehicles on a credit of 14,60,000. But subsequently did not pay the amount, and also started avoiding the phone calls. Full stop. The present petitioner is not named is stated to be not named in the FIR, and it is stated, it is submitted that he is the brother of it is submitted that his elder brother, what is the name of the elder brother?
Ashraful.
Ashraful has a used car dealer shop. Used car dealing shop. Call for the case diary from the concerned police station. 25,000 1 appear before the IO. What is this other one?
Other or not, he is a businessman. He is also issued with same case. He is a businessman,
Not named.
not name FIR.
Similar. Elder brother partner.
Businessman.
The present petitioner is stated to be not named in the FIR and that he is a businessman.
I am obliged. It is the date.
29th.
29/1.
Obliged.
This order you need, or
Right.
should I keep it?
No, sir. I have it.
May I plead your lordship? My lord, this is an application praying for pre-arrest bail of the petitioner, my lord. The FIR, your lordship will find at page 17, my lord. Operative portion at page 18, my lord. The petitioner is not named in the FIR, my lord.
Against her own husband, she said.
Yes, my lord.
That's good. People can be this frank then.
Yes,
It's also appreciated.
after that, my lord, on the basis of the FIR, my lord, these three named accused were arrested, my lord, and they were forwarding report at annexure 5. And my lord, Caesar list, your lordship will find at page 22, annexure 6, my lord. Caesar list, my lord, the one original migration certificate of so-and-so in the name of Shoaib Ali, the husband of the informant. One original certificate of secondary examination, one original statement of marks of so-and-so, so-and-so. And after that, my lord, the petitioner, my lord, petitioner is the headmaster in charge of the center, my lord, where this distant education course was going on, my lord. So, my lord, after that, my lord, the petitioner was also called for interrogation, my lord. And one document was also seized from him at annexure 7, page
No,
20.
this is the complaint was lodged that
Yes.
this in Nilbagan market area,
Yes,
so and so, this illegal business, these people are running. This is
Yes,
the
sir.
allegation, right?
yes, my lord.
And she says that her own husband had also once used such certain
Certificate.
document
And
to
certificate
contest
paid-
election,
Yes, my lord.
to participate. Now, this petitioner, who is this petitioner? Abu,
Petitioner is the headmaster, my lord, in charge of he is a teacher and now he is the headmaster of Digholi Pukhuri High School. Digholi Pukhuri High School, my lord.
headmaster of Deganipuri High School.
Digholi Pukhuri High School. And that high school has been approved by Delhi State Open School to run a study center, my lord. For dropout students, school dropout students or
Well, okay, Delhi State Open School.
yes, my lord.
What
That
is
annexure 1, 2, and 3, my lord. The service ID of the petitioner.
That is at page?
Page 14, my lord, annexure 1. It is the service ID of the petitioner. And then annexure 2, my lord, by which the petitioner has been handed over the charge of the headmaster by the outgoing headmaster, my lord. Annexure 2, my lord. Annexure 3 is the
Because he
authorization.
has been summoned. He
Yes,
has
sir.
been, he has been given a notice to appear. That is why
He-
he's apprehending.
No, he has been called many times. He has appeared that the register book or other document have also been seized. Annexure 7, my lord, page
So
24,
he
my lord.
apprehends that he may be arrested also subsequently.
No, he has not been arrested.
But he apprehends.
He approached the learned session judge, my lord.
Mm.
Initially, he was granted interim bail, my lord.
Sure.
Subsequently, the interim bail has been rejected.
I have found some materials.
Yes, my lord. Annexure 7 is the, my lord, document which has been seized from the petitioner, my lord.
Mm.
One orange colored admission registered in which written name as so and so, so and so, so and so. It has been, the petitioner has been interrogated many times, my lord. So whatever documents were asked for, my lord, he has produced and it has been seized, my lord. Then, my lord, annexure 8 is the order by which the petitioner was granted interim bail. Annexure 8 at page 26, my lord.
No,
And mine is a
the
just note.
order says, you fairly annex the order also, that's okay. Abu Hanifa was the main person who ran the
Yes.
local center for providing certificate. No, running the local center is not a problem.
Exactly, my lord.
But if he's providing
Providing-
fake certificate,
yes.
that is a problem.
My lord, that I am pointing out, if your lordship comes to annexure 11 at page 33, because all the certificates, whatever is there, my lord, all are in the official website. It is the certificate, mark sheet of that Shuaib Ali, my lord. It is downloaded in the official website of the university, my lord. And my lord, secondly, my lord, another order dated 24/12/2025, annexure 10, page 30, by which the other 3 persons have been allowed to go on bail. There, the learned court has recorded in annexure 30, my lord, annexure 10, page 30. It is an order by which the 3 named accused, my lord.
Hmm.
Shahid Ahmed, Rafiq Ahmed, and Zakir Iqbal Chaudhary. Out of 3, Shahid Ahmed was on interim and his interim bail has been made absolute. And the other accused persons have also been allowed to go on bail after being detained for 20 days. Here, my lord, in page 31, in 3rd paragraph, your lordship will find a observation. Page 31, if your lordship kindly come to page 31,
Yeah.
para 3. Learned public prosecutor, after scrutinizing the case diary, could not show any seizure list, which shows that the alleged fake false metric pass certificate was seized relating to Delhi State Open School. So, my lord, no fake documents have been seized because they have seized 3 original certificate mark sheet of the Shuaib Ali. And from the petitioner, from the school records, whatever they have asked, my lord, petitioner has been interrogated 3-4 times, even before the granting of interim bail and even after granting of interim bail. And thereafter, he is the headmaster, he is running the local center, how he can manufacture a forced document? Because whatever documents the Shoaib Ali has got, all documents have been.
His school is the local center.
Yes, my lord, that is a school and that is a local center. And those documents, annexure 11, page 33, it has been uploaded in the official website of the concerned university, my lord. The petitioner being the in charge of the local center, he doesn't have any role to play in the making forged or fake documents, my lord. Apparently, my lord, it is clear. And other 3 persons, my lord, they have been allowed to go on bail. And secondly, my lord, what I am submitting, let the investigation go on, my lord. The petitioner is cooperating with the investigation. Documents, everything is available with the school authority or official website of the university, my lord.
No, the only thing is that earlier the petitioner was granted interim protection.
Mm.
Later on, after closure of the records, he was rejected.
But let us see what the timing. DP Bora and DP Goswami. 482 in connection with Murajhar PS case number 252 of 2025. no? Which was registered based on an FIR dated 3/12/2025, lodged by lodged at the said police station
Page
by
18, my-
Sajina Begum with the allegation that some persons and shops in the Nilbagan market area were indulging in illegal business of making fake and fraudulent documents, which are used for procuring various other government documents fraudulently. And stuff. The 4 accused persons are named in the said document. The present petitioner, Abu Hanifa, is not one of them. He's not named in the FIR.
No, my lord.
And he's stated to be the headmaster of, what is the name of the school?
Headmaster of Digoli Pukuri High School.
Of Digalipuri High School, which is one of the centers of the Delhi State Open School. Full stop. Mr. Bora, Learned Counsel, fairly submits by referring to the annex documents that he, on his bail preferred before the learned court below. Though he was granted interim, but subsequently the interim was cancelled. It is further submitted that however, three other persons, they are named in a,
Yes, my lord, named accused.
the three FIR name accused persons have been granted bail. In the referring to order dated 24/12/2025, in this regard, passed by the learned court below, the Petitioner Counsel submits that, draws attention to the submission of the learned PP before that learned court, that the case diary has not shown any seizure list showing seizure of any fake metric pass certificate relating to Delhi State Open School. It is submitted that the petitioner has been rendering his cooperation and has appeared before the IO prior to and also after the interim order was vacated.
And certain documents have also been seized, my lord.
And some other documents have also been seized. Call for the case diary, however, in the given facts and circumstances, it is directed that entry 25,000 answer and for evidence examination. If necessary, he can appear again, submit any documents.
Yes, my lord, here. Interim has a protection has been granted, my lord.
Fix on
28 one.
28 one.
My-
Oh, yeah, interim.
Yes, interim protection has
Yes.
been deeply obliged, my lord.
May it please your lordship. So this is regarding the same matter which your lordship has already heard, item number 2, that dog bite case, my lord.
Hmm?
The dog bite case, my lord, where the
Ah.
child unfortunately died.
Mhm.
So in item number 2, that was the pharmacist and the owner of the pharmacy.
Hmm.
The petitioner before your lordship is an employee there, my lord.
Yeah.
Your lordship will see already seen the FIR.
Mhm.
which you also will find at page 15. But certain things are admitted. We admitted by the informant that the deceased had sustained a dog bite. Then the deceased was taken on 29th of November to the FRU. FRU, the doctor gave an injection. The second dose was scheduled to be given on 2nd. On 2nd, they go to the FRU. In the FRU, that injection was not available. So they go to the pharmacy. So now, my lord, the administration of the injection, which was prescribed by the very doctor who was treating the patient. Now, if there is some unfortunate outcome of administration of that injection, my lord, leading to the death of the child, my lord, this does not come under the purview of section 105, my lord, because I neither have the intention nor the knowledge that an injection which has been prescribed by the doctor, if I am giving that, that will lead to the death of the child, my lord. Your lordship has already given interim protection to the.
It's very unfortunate, but we don't
Unfortunate,
know
my lord.
the medicine, because nowadays counterfeit medicines also there, because sometimes the person in a pharmacy may know or may not
May
know
not know.
about counterfeit. But the owner may know sometimes, usually, but we don't know otherwise. It's okay, no problem. So there must have been some violent reaction.
My lord.
due to
There's
which he
also
died.
something, my lord, because when the child was brought in, my lord, this child had been beaten almost a fortnight before this incident. So that could also, that postmortem report will reveal, my lord, what was the actual cause of death.
Each person is the,
He's an employee there, my lord.
I don't know. I got to know. Heard. Yes, Nawaz and Sunil. The present petitioner is stated to be an employee of the said Raj Medical, where the dog bite rabies injection was supposedly administered to the victim boy.
And this petitioner is admitting that he had given the injection, my lord. Your lordship may reflect that also.
So the learned counsel fairly submits that he had given the injection on good faith upon being recommended by the doctor of Dhing FRE. Full stop. And therefore, full stop. And therefore, he cannot be attributed with the knowledge of causing any harm to the child. And that's full stop. Nevertheless, one thing I was pointing out in the earlier thing is that if you have a call for the case there, 25,000 watt COT, you will record his statement.
My lord.
Okay. I was pointing out, the last thing, this part I have not understood. Forcefully administered the injection, this, I don't know why. they
Generally,
said-
pharmacist never forced to take injection, generally.
Nobody can force anybody to, well, perhaps because the child has died, well, that has also led to some trauma to the informant. also.
Forcefully,
Maybe that may be a
that
reason.
part I have not understood. Anyway,
On 27 on lordship, same date.
He'll appear and record his statement, my lord. I'm deeply obliged.
My lord, item number 54 and 56 out of the same affair, my lord. Item number 54 and 56.
54 is also yours.
My lord, out of
Okay.
the same affair. 54 is the, my lord, bail application, my lord, and
Which one should I take up first?
my lord,
No, I should take up the BA first.
my lord. My lord, this is regular bail application, my lord. Kindly call for the CD, kindly have a try on 9, my lord. Both the cases, my lord, from Sulawesi River Police Station.
Yeah, you're not seeking interim here.
My lord, in item number 56, I am seeking interim, my lord.
56.
Already the informant given an affidavit, my lord. Already they have amicably settled the matter, my lord.
What if settles? The setting fire to the house.
My lord,
So here only we'll call for the case diary.
my lord. Kindly on 9, my lord.
Allegation to me to him too. Yes, as a bush. Call for the case diary of Kolkusi River PS case number 66 of 25. So the accused was arrested on 15/12/2025. With regard to this case, which was with regard to this PS case, which was registered based on an FIR Based on FIR dated 1/12/2025. Naming 7 persons therein. With the allegation that on 27/11/2025, in the night, while the informant's husband was not at home, the FIR named accused persons entered her house and pulled her out of the house along with her children and set fire. As a result of which the dwelling house and accessories got burned. So, call for the case diary from the concerned police station. 9/1,
My lord,
That, facts are exactly.
9/1. He is named in the FIR.
my lord,
This person is.
all are named in the FIR. But this is not dwelling house, but abandoned house, my lord. This is a shop, my lord.
Acha.
There are going some land dispute between the parties since long, my lord.
So if you can wait 3 days, we'll call for the. This is.
My lord.
This is AB, 14. Fix it on 9.
My lord. Highly obliged.
This is second bail application, Lordship.
Hmm.
Earlier bail application was rejected during investigation stage, Lordship.
Okay.
And he was the owner of the vehicle from where allegedly contraventions were recovered.
Mhm.
And Lordship may kindly see your Lordship's order at page 11%. I'm referring to page 24.
Just a minute. In the meantime, we have got the complete case diary also. I
Yes,
think.
got
Probably.
Case diary received, Lordship, that I have.
Okay. You want this? You want
Yes,
this?
Lordship.
Yes, I'll just.
Lordship.
Stamp
Page
it and come.
24, Lordship.
Where should I see? Page
Page 24.
24. Okay. This was the anticipatory bill, right?
Yes, no, Lordship.
No, earlier one was. Oh,
BA,
it was beyond.
but that was during investigation.
Ah, so-
Paragraph 10, page 24, Lordship. So those were the materials during investigation, and now they have submitted charge sheet, and from charge sheet also it appears the status is same, Lordship.
Nice. Only
That
material is. the-
Only material is
That
that.
you confirm and otherwise.
And in fact,
Perhaps this principle can be applied, right?
yes, page 41, your Lordship will find
Hmm.
that part, that is a charge sheet, Lordship. There, the roles of the accused persons are mentioned, and here also that same thing, that because I am owner of that truck, I have been arrested. That is mentioned in the charge sheet also. Page 41. And phones were seized, CDR details were collected. That is between other accused person, not with the present petitioner also. And I have enclosed one document, Lordship, that page 45, that vehicle was given on hire to other person, Lordship.
And the other person, in turn, hired this driver and handyman.
Yes.
You go through it, Goswami, you go
Lordship.
through it. We'll dictate the factual part.
Lordship.
In the meantime, you go through it. You done? Anything else you want to say? Nothing?
That is my permission,
Let
Lordship,
him,
except that.
let him go back.
Nothing.
I'll record that.
Lordship.
It took order of law, right, first, factual part. It's A. Ahmed, DP Goswami. Page 22 doesn't. This is a subsequent bail application. The earlier bail petition was rejected on 6/8/2025 in DA 2070/25 at the stage of investigation after perusal of case diary. There are 2, 3, 4. The present accused was, so who's stated to be the owner of the vehicle, was arrested on 11/6/2025. Primarily on the statements of the driver and handyman who are co-accused. Mr. Ahmed, learned counsel submits that the earlier bail petition was rejected at the stage of investigation. But in the meantime, charge sheet is completed, charge sheet has been submitted. And the completed investigation, in the completed investigation materials also, the only incriminating material is the statement of the co-accused. And the learned counsel seeks the benefit of the principle laid down by the Honorable Supreme Court in the case of Tufan Singh versus the State of Tamil Nadu, 2021 4 SSC, page 1, in which it has been laid down that conviction in an NDPS case cannot be based on the statement of a co-accused, solely on the statement of co-accused. The updated record was called for and has been received. Good stop. Before proceeding further. Sure.
These are the citations, Lordship, I'm relying on, Lordship, that Tufan Singh can be relied on during for bail applications also, Lordship. That
This-
is a consistent view of Honorable
Supreme
Apex
Court
Court.
doesn't.
Lord.
This one?
The first one is of Honorable Apex Court, Lordship,
Apex
that's Falula Bill,
No, where it has been said in the Apex Court
paragraph
judgment?
10, Lordship.
The Apex Court judgment.
Yes, paragraph 10.
Yeah, it
But-
can be taken into account. Appearing special date. Where it says, refer to this.
And the other one, Lordship, that Nure Zaman Islam, that is at paragraph 8 onwards, Lordship, that section 37 has been discussed. And then, Lordship, only because there was confessional statement and therefore bail was granted, Lordship. That was prior to Tufan Singh, Lordship. This order was passed. And the third one, Lordship, that Ahadul Hussain, here, Lordship, paragraph 20 to 24, Lordship. On section 37. And regarding Tufan Singh at paragraph 26.
Yes,
Only thing is that driver and handyman implicating the petitioner.
that's all.
Yes,
I think go on bail.
yes.
Save the trial. He has been sent. Upon perusing the materials of the case, the learned prosecution fairly submits that the materials collected during investigation against the petitioner are the incriminating statements of the co-accused, being the driver and the handyman of the vehicle. Full stop. In view of the same, and keeping in mind the principle laid down in Tufan Singh Supra, therefore also perhaps the accused can be granted bail at this level. Even if 37 is passed, he
Yes.
still refuse bail. But it's okay. But if 37 is not passed, then even with other factors, they require, they indicate giving of bail, then in a way, your hands are tied, as we know. In such view of the matter, the given facts and circumstances, the accused is little bit higher, 75,000, with one surety of the like amount, to the satisfaction of the concerned learned court, which is special judge
Srivu.
Sri Bhumi, very much. And subject to the conditions, number one, he shall be available for the trial if one commences, not hamper or tamper with evidence. He shall he will not misuse his liberty to commit any offenses. Stops. Or illegal activities, including any activities prohibited by the NDPS Act. Can I keep this?
Lots.
Now, my earlier order had taken a view, but I don't know if it is taken up higher, then only we'll know whether it is correct or not, cross-checked by a higher court. Because I had said that at the stage of investigation, on the basis of those materials, so suppose somebody may argue like this also, that it has to be decided on the basis of materials prevailing at that time. So
Right.
if there are no materials, then also 37 can be passed in my favor. So
Right.
that can also be an
That
argument.
also. But Honorable Supreme Court has clarified
So
that,
if these
that
are-
during
If it is taken
investigation.
up, yeah, then, but bails are usually
Right.
not taken up. Obliged, Lords. Dispose of.
17.
May I please your lordship? I have completed 63 days, my lord, is a 406 case, my lord. And I am a patient of cardiac attack, my lord. He has been forwarded to the medical college by the jail authority, and your lordship will surprise that how he is surviving. Major portion of huge blockage of his heart, my lord. And he is still under treatment, my lord. In the term 63 days, I am behind the bar, my lord. So statutory period is over. The charge sheet has not been given. Yesterday also I have inquired, my lord. He's in the hospital. I think CDS also has come.
Madam, if he has completed his statutory period, madam, then he can approach the trial court, madam.
This court also can grant. My lord, I am in the hospital, my lord. They could not release me because my petition is pending in the High Court.
Well, statutory bail can be given by lower court also, but we can also give, any court can give actually.
Yes,
This is true, madam, the 63 days, madam,
That's true.
and investigation is pending, madam.
but
Investigation is
statutory
pending.
period is over, my lord.
Statutory period is 60 days.
Yes.
What are the sections given?
My lord, section is 319, 336, 125, BNS,
All
and
60 days,
271.
all 60 days.
Yes.
I need not cross check. No? So,
There the medical certificate, he is 99% blockade is there.
he has to go undergo surgery. Okay. Diary has been received? No.
Yes, there is, madam.
Investigation is not yet.
No,
complete.
yes. it
You
is-
cross check that. Sir must be correct, of course, but you just cross check it. I will order it. We'll look. It's CV source and RJ Borough, second and third paragraph. Diary. The accused was arrested on
Arrested on my lord 5/11/25.
5/11 to
25.
The case diary has been received and it is submitted by the prosecution that investigation is still in progress. Good stuff. Mr. Biswas, Learned Counsel submits that the applicable statutory period will be 60 days, which is already over. And as on today, the petitioner has completed 63 days. It is also submitted by referring to medical documents that he is presently hospitalized with heart ailment in the nature of blockades.
Maximum punishment is 5 years, my lord. All the others are 2 years, 6 months, 3 months.
And the given facts and circumstances. The petitioner is allowed to go on bail of rupees 25,000 with one surety of the likeness to satisfaction of the concerned learned
CGM, say, Kacha Silchar.
that's all. And subject to the condition that he shall be available for trial upon commence. He shall not hamper or tamper with evidence.
My
He shall
problem
not-
is he has to go for bypass. There is a suggestion immediately to go for bypass. Otherwise, he may die at any time.
He shall cooperate and he shall not hamper.
He will cooperate with him.
Second,
66
third,
years old
he
man,
shall
madam.
not misuse his liberty to commit an illegal activity.
Obliged. Deep
Done.
obliged.
Cross-checked. You take this back.
Yes, I will collect it.
Disposed of.
Yeah.
Please, your lordship. For your last order, the trial court record was being called for and the case diary. Case diary ऐसी नहीं है। Kindly see the 18/12/2025 order. My lord is there.
This can be received, my lord, as per the, my lord.
The reason for calling for the TCR was, my lord, we applied for the certified copies. But when we received the copies and on perusal of it, the copies were incomplete. And accordingly, this honorable court, let's call for the case diary, TCR. But the case diary is required. On merits, my lord, the question is that my name is not there in the FIR and the reasons of arrest and grounds of arrest, that issue is only there. But for that, your lordship has to peruse the case diary.
What is the
Allegation is that, my lord, kindly come to page 19. With due respect, my lord is there?
Yes.
With due respect, I would like to draw your attention that today, that 13/11/2025, the below noted accused persons belonging to Muslim community equipped with machete and spear broadcasted news on various news channels threatening to cut off indigenous people and drown them in river. The news has drawn attention of indigenous people raising concerns of serious communal disharmony which may trigger communal clash, hampering fraternity among the mass. Therefore, to brought the accused persons under purview of law and punish rigorously, and also to tackle and diminish possibility of such situation in future context, I kindly request you to register a case and take necessary action against the below noted accused persons. My lord, 9 persons have been named. My name is not there in the FIR. Now, the case was registered under 196, 197, 299, 302 and 152 and 258 BNSS. Now, your lordship will kindly see
302? Why?
302, 152, 258 BNS. 302 is uttering words, etc., with deliberate intent to wound religious feelings of any person.
Yes.
My lord. Now, kindly come to page 24, my lord.
He was arrested on, this person is arrested on.
My lord, I was arrested on 15/11/2025.
In 11/2020.
15/11/2025. Now, my lord will kindly come to the page annexure 3, page 24. This is they are saying that there is a grounds of arrest. Kindly see, during investigation, it has come to light that some video broadcast in electronic media by accused persons openly threatened to cast Assamese public and throw in river Brahmaputra. Those accused persons means only those 9 persons, my lord. My name was not there in the FIR, otherwise my name would have come. The accused persons openly insulted Assamese people. So my name is not there. The accused persons tried to attack Assamese public, but name was not there in the FIR. Nor even I was being identified in the FIR. So this was what they did was that as a bracketed one, they put this grounds of arrest. Now what my contention was that even when we applied for the copies, the certified copies, the learned committal court, CGM, did not record what were the grounds of arrest specific, because your lordship will appreciate that recently this honorable courts in Kesoto tapes case has elaborately said that grounds of arrest and reasons of arrest are 2 different things. And if their grounds of arrest is becoming a questionable, then from the case diary, it has to be ascertained whether it was been recorded or not. Otherwise, my lord, on merit also, my lord, the offences don't come up, my lord.
Anyway, so
Looking at the period of custody, because at serial number 37, my lord, kindly come to page 38, my lord. Page 38
of your petition.
of my petition. The IOS categorically says that my custody is not required also in future, because there is nothing of recovery, nothing of anything. Whether assistance of serial number 7, 7, 8, 9, 10. Because of the new BNS, that checklist has to be done. Yes, categorically said that my requirement custody is not required.
Police
Look,
custody is not.
my custody.
Anyway,
The scan copy, I have not been able to go through, my lord. Scan copy, my lord.
Can I have TCR?
Yes, my lord. Scan copy, the case diary, my lord. That I have to.
it has been charge sheeted. Case has been,
No,
investigation is going on.
It has not been certified.
Investigation is going on.
It's still going on, my lord.
Then,
Because
but
90 days time limit is there.
we'll call for the case diary, my lord, then. Case diary today not received, my lord,
This
but
much we have
it's a
received.
scan copy of PCR, my lord.
TCR is there, my lord.
You have a look.
Yes, ma'am.
This is suffices then also. We can dispose.
38 খনত আপোনাৰ চব আয়োগ কৈছে আমাৰ তাক কাষ্টডি নালাগে বুলি কৈছে চেকলিষ্ট খনত 38 খন
You can have a look.
My lord.
any conditions may your lordship
You're trying to say that basically, if I understood correctly, that the grounds of arrest, these grounds of arrest would not be applicable to him
exactly, my lord.
because he's not named in the
It
FIR.
is not named in the FIR. Because if my name was there, if in the video I was there, of course my name would have to be reflected.
Some police persons do certain things. They should not get to it.
Here, my lord, the case diary is not there, my lord. Only the, my lord, ground of arrest and the order sheets are there, my lord.
Huh.
So, my lord, what are the materials accuracy, my lord, that will be reflected from the case diary only, my lord.
So you have to ding, no? Ding. When can you get it?
My lord, Lord, we have fixed it on 9th, my lord, immediate.
The scan record has been received, however, learned additional PP RJ Bora admits that his diary is not there. The petitioner was arrested on 15/11/25 in connection with Dhing PS case number 277 of 25. Full stop. Mr. Borgohain, learned counsel, the petitioner submits that the petitioner is not named in the FIR and the grounds of arrest have been given mechanically as these would not be applicable to him. Full stop. Nevertheless, the perusal of the case diary might be necessary. Therefore, issue reminder for the case diary fixed on 9/1.
19.
9/1.
Oh, no, sorry,
Friday.
9.
9 Friday.
Oblige, your lordship.
May it please your lordship. Lordship case diary perhaps received. Item number 41 and 42 also arises out of same PS case number. That can also be taken up together.
41 and 42.
41 and 42. In item number 41 also I am appearing.
Yes, there is.
First, let me take up the BA, then other three are AB. We'll
Lordship.
take it up together. First, I'm taking up 20.
Item number 20, my lord. The FIR your lordship will find at page 13. FIR at page 13. The present petitioner is also not named in the FIR, lordship. He has been arrested on 10/12. The present petitioner is, lordship, the assistant teacher, and his retirement date is due after 50 days. In the month of February, he is going to retire. Lordship, may I read the FIR? FIR at page 13.
Yes.
With due respect, it is stated that on 15/11/2025 at around 12 AM midnight, the accused persons mentioned below, along with 15-16 other people, arrived in four-wheeler vehicle and 3-4 motorcycle. They come armed, disguised in army uniform, and unlawfully entered the house of my elder brother Mohuruddin. The accused number 1 attempted to abduct my sister-in-law Julekha Bibi by forcefully dragging her towards the village road. On her arising an alarm, nearby villagers rushed to the spot and rescued her by stopping the accused person. My lord, here the allegation is against the accused number 1, very specific, and the present petitioner is not also named in the FIR. For a moment, my lord may come to page 28.
Just a minute.
Page 28.
Yes.
Page 28. Page 28 is the medical document of accused number 1 and accused number 2, my lord. Page 28 onwards.
Medical document of accused number 1 and 2.
Accused number 1 and 2.
Hmm.
Present petitioner is not even named in the FIR, my lord.
Hmm.
My lord, page number 28, it goes to show that accused number 1 was admitted in the Dhubri Medical College for 10 days, my lord. From 16/11/2025.
The petitioner.
Not the petitioner,
The
accused number 1. Accused number 1. And he was discharged on 25/11/2025. And the injury, lordship, they have sustained may be seen for a moment. Page 30 and 31. Page 30 and 31. The named accused, they were brutally beaten up, my lord. Their bones are broken, my lord, and steel plates are fixed in their leg. The image shows page 30 and 31.
The incident took place on, allegedly took place on,
The incident took place on 15/11/2025.
and he was admitted, he was beaten up
He was beaten up
in the incident. And
in the incident,
he admitted on 16 and then 25/11 he was discharged.
discharged. Lordship, since the accused number 1 and accused number 2 were brutally beaten up, lordship, a cross affair has been filed, lordship. A cross affair has been filed that your lordship will find at page 20. Page 20. My lord, this cross affair goes to shows that the accused number 1 and accused number 2 in the previous affair, lordship, they visited the house of the first informant's home,
Page
lord.
20.
Page 20 is the cross affair. This affair is lost by the brother of the present petitioner, lordship. And he is also the brother of the person who were brutally beaten up, my lord. This affair has been filed because his brothers are beaten up, my lord.
Sir, just a minute. Facts of the incident. Accused
Page-
number 1,
Page 20.
Julekha Bibi.
Both the affairs are registered in the same day, my lord. One is PS case 74 and another is PS case 75.
So due to some relationship, they were called according to your affair.
Lordship.
Hmm.
They were having some illicit relationship, the accused number 1 and accused number 2. So there was some dispute. And so they visited the victim's home, lordship. And in the previous affair, it is categorically stated that the accused number 1 tried to drag the victim. The victim is also a married woman, my lord. So, lordship, the present petitioner who is not even named in the FIR, and the case is that, my lord, the present petitioner is working in the same school where the victim is working. So, this is not a case that while registering the FIR, lordship, they do not know the name of the present petitioner, lordship. Injury is sustained in the part of my family member, my lord. And since another cross affair has been lost by my brother, I mean, he is the petitioner in item number 41, lordship. That is why they are running after us, lordship. Although my name is not there in the FIR. And police is not taking action against the other party, my lord, who has caused the injury to my family member. And the injury has been seen by this honorable court.
Just a minute. Yes.
Further, the forwarding report goes to shows that, my lord, the police has not even asked for police remand for even 1 hour. He has requested simply to judicial custody for 14 days, my lord.
Atwar Rahman, no?
My lord, Atwar Rahman.
Atwar Rahman. Who's the petitioner here?
He is the petitioner. He is not named in the FIR, lordship. He is the BLO also, and he is going to retire on February 2026.
Yes.
Lordship may see the case diary.
Let
kindly.
me-
So injury report reflects lordship, one person grievous hurt and
Is it a case of mutual assault?
mutual assault.
Huh?
Case of mutual assault, both parties are confronted took place, confronted plan and assaulted each other, lordship. And injury part of some persons who injuries is simple and blunt weapon, someone is grievous. And witnesses, and going to the case, the witnesses and victims also implicated the petitioners. All 20, 21, 41, 42, I have already cross-checked. Their name is there. They have implicated that yes, they were assaulted by these petitioners. Someone stating is saying is that this person is Ayub Khan Chaudhary.
I am Atwar Rahman. My name is not there.
Yes,
And
Atwar
I
Rahman
have
also
been-
implicated by the victims and witnesses also. We are present. As per going to a statement of the witnesses. Lordship.
The statement of the witness is, your lordship, afterthought, because in the FIR, lordship, the allegation is very much specific towards the accused number one. And the present petitioner and the victim, they are serving in the same school. So this is not a case that the victim does not know the present petitioner, and thereby the name of the petitioner has been escaped. Lordship has seen the injury.
Injury, some persons were grievous and by blunt weapon, some persons were sinful by blunt weapon. Laceration was there.
And the
One
accused
document
number
of
one,
laceration
accused
of-
number two, they were recovered by the police personnel, my lord. They were in unconscious stage, my lord. And in the FIR, they have alleged that the accused are in army uniform, lordship.
As per the statement, they have forcefully entered the house and try to assault the petitioners and try to molest the ladies also.
It is there, it is there. I am not denying the fact,
But
lordship, but
that-
that is specific toward the accused number one and two.
That's why they are abducted and confined in their home, lordship. Later on, police came and they rescued them, lordship. Laceration over forehead of 3 into 2 into 1 centimeter square, lordship. And other persons.
The legs and bones are broken by the other person, lordship. They're my family member.
Anyway,
That is why cross FIR was been filed.
this, let him go.
That's
Let him go on bail, this person who's in custody.
within custody.
He's going to retire also, but AB will have to see whether
Yes.
it will be justified. Anyway, so let me first tackle this.
Atwar Rahman, lordship.
Atwar Rahman. Third, you, Mr.
R. Karim, my lord.
R. Karim Islamic Council. GP Goswami, seeking, invoking 483. Bagribari PS case number 74 of 20. The petitioner stated to be aged about 60 years, was arrested on 10/12/2025. The case arose out of an FIR dated 15/11/2025 lodged by one Johirul Haq, with the allegations that on that day, at around 12 midnight, the accused persons, the two accused persons named therein, that namely Ayub Khan Chaudhary and Mofidul Haq, along with 15-16 others, came to their house in four-wheeler and two-wheelers, disguised in army uniforms, and illegally entered the house of elder brother, informant's elder brother Muhuruddin. It is alleged that the accused number one attempted to abduct his sister-in-law Julekha Bibi, but on raising alarm, the villagers rushed to the spot and stopped. And at that moment, the accused persons assaulted the informant's side with iron rods, causing injuries to the informant, his brother, sister-in-law, and others. Full stop. The two accused persons mentioned in the FIR were apprehended and others escaped. It is submitted that these two accused persons who are named in the FIR were brutally beaten up, leading to fractures. And in this regard, the petitioner has drawn my attention to the annexed medical documents indicating admission of Ayub Khan Chaudhary therein from 16/11/2025 till he was discharged on
25/11/2025.
25/11/2025. The medical report indicates fracture. Full stop. It is submitted that with regard to the incident and of causing assault upon the accused persons, an FIR, another FIR was lodged. It is at page number on the same day,
Page 20. The case of FIR.
naming 5 accused persons. With the allegations of causing grievous injuries to to Ayub Khan Chaudhary, stated to be the brother of the informant therein. The case diary has been received. The learned additional PP submits that it appears to be a case of mutual assault. And though the present petitioner is not named in the FIR, but the implications against him as well. Investigation has progressed.
Yes. Medical report already received.
The investigation is stated to have progressed reasonably with medical report received. Considering that aspect as well as the length of detention, the present accused allowed to go on bail of rupees 25,000 once you cooperate with remaining investigation and he shall not hamper or tamper with it. Return back case there. The others are all AB, right?
Yes.
Item 21.
Because they've been given interim here.
Yes,
Like
But
all the
one
ABs,
person- one
all
num-
the ABs, they're on interim.
they appeared, my lord, before the IO. And in
The
fact,
Other two,
accused number 1, my lord, he is in, my lord, Chennai at present. He is under treatment.
Ayub Khan Chaudhary.
Ayub Khan, he could not appear because, my lord, she is in Chennai. Her, my lord, bones are, my lord, broken.
Statement of number 2 is yellow.
Mofidul Haq.
Yes.
Mofidul, my lord, appeared before the IO. And his statement has been recorded, my lord. He is also under medical treatment, but he appeared somehow.
And one is in Chennai.
Chennai,
It was আগৰ নিচিনাই হ'ব।
because both the legs are broken.
Allegations to know. আমি অলপ আৰু details দেখিছোঁ, বুজিছে? এইটো ল'ব পাৰে আপুনি। আৰু photo লৈ ল'ব পাৰে। Case diary has been received, full stop. Ayub Khan Chaudhary and Mafidul Haq.
Mafidul Haq statement recorded by implicated the witnesses and victims.
Full stop. The present, the petitioner number 1, Ayub Khan Chaudhary is stated to be in Chennai undergoing treatment for the serious injuries / fracture suffered by him in the incident in which he was assaulted. He was also assaulted. And it is further submitted that though petitioner number 2, Mufidul Haq, also sustained injuries, but he managed to appear before the IO in terms of the interim order dated 9/12/2025. Investigation, it is submitted by the learned additional PP that investigation has progressed and medical report is also available, but the statements of witnesses implicates the petitioners. Nevertheless, the interim bail in favor of petitioner number 2 is hereby made absolute. And full stop. With regard to petitioner number 1, 30,000 with one security of the like amount to the satisfaction. He'll cooperate with the investigation and shall not hamper or tamper with evidence. I'm not giving appearance because it's in Chennai.
Well,
Okay. This is AB 2887, item 21.
give the please.
My lord, next is item 41. I am appearing in item number 41. He was also granted interim bail by this honorable court. And the petitioner is not named in the FIR, And the present petitioner is the informant in the cross case, Lordship. He has also appeared before the IO.
Submitted that the present petitioner is the informant in the cross case lodged due to injuries upon some of the accused persons of this case. And he was granted interim bail on 17/12/25, whereupon he appeared before the IO in his statement report. He is also implicated.
Yes,
All-
implicated. All the persons are implicated.
All implicated. Interim is made absolute, subject to the condition that cooperate with remaining investigation. Shall not hamper or tamper with evidence and shall not misuse his liberty to commit any illegal activities or offences.
Oblige, your Lordship.
42 is
42, my lord. The petitioner is interim, my lord, and appeared before the IO, my lord, and he is not a FIR name.
The petitioner
42.
42.
Statement recorded, he has appeared.
Appeared.
Same,
40
all witnesses and other persons are implicated. Lordship.
same of what you are.
Same order.
He is stated to be not named in the FIR. Full stop. However, he was, the prosecution submits that he is implicated right in the statements of the witnesses. The in view of the progress of investigation and fact that some of the co-accused have been granted bail, I'm not inclined to cancel the interim of this petition. Therefore, the same is made absolute subject to those conditions.
Oblige.
May please the lordship. FI is page number 11. May I read that?
Yeah.
May I read that? সন্মানপূৰ্বক বিনীত নিবেদন এই যে স্বৰ্গীয় মানৱ ডেকা মোৰ দাদা হয়। যোৱা ইংৰাজী 8-11-25 তাৰিখে মোৰ দাদা স্বৰ্গীয় মানৱ ডেকা আত্মহত্যা কৰে। প্ৰকাশ থাকে যে উক্ত পদকীয়ে ৰাণু ডেকাৰ সামাজিক মাধ্যমত প্ৰচাৰ চলোৱা পোষ্টক লৈ মোৰ দাদা আত্মহত্যা কৰিবলৈ বাধ্য হয়। On the basis of this FIR, Your Lordship, I was arrested on 14/11/2025. And while forwarding me, the police has not sought for any police remand. And I'm in the judicial custody for 53 days now. So what has happened is that, Your Lordship, I am married and I have 2 children. And the brother of the complainant was constantly harassing me for marriage. Being married and having 2 children, I denied. And thereafter also, after such denial, the brother of the complainant was constantly harassing me. And in such a circumstance,
For harassing for marriage. Marriage
with me. I'm married and I have 2 children.
Acha.
Now,
He was forcing you to get married
with him,
The deceased.
the deceased, Your Lordship.
with the deceased
Yes, Your Lordship.
girl, his sister.
And in such a circumstance, after being harassed so much, I posted in Facebook that Manav Deka is a TD suit.
Huh?
Manav Deka is a TD suit. That is the only allegation, Your Lordship. I've been in the judicial custody for 53 days, Your Lordship.
Witnesses are stating same thing, Lordship, what my Lord has needed. But someone saying that there is a relationship between them, the disease and the petition. Some statements were made by the account of the petitioner's brother. That type of language is used in the post. And that FSL report is received, Lordship, no poison and its metabolites were detected.
Is the Facebook post available?
Facebook post, yeah, Lordship, in the name of Rajdeep Dekaita, is the name brother of
I'll have a look. Huh?
Lordship.
Heard the good name is? Mr.
Jay Das.
J. Das. 483 bail applications. By Atta Sarile PS case 277 of 20. The petitioner was arrested on 14/11/25. The on 9/11/25, informant Bhavesh Dega lodging the alleged that on the previous day, that is 8/11/25, his elder brother Manav Deka committed suicide. And that the accused petitioner Ranu Deka had shared a social media post which had led to his brother's suicide. It is submitted by the learned counsel that that the petitioner seeking bail is the married lady having children. And that the brother of the deceased was forcing for her marriage with the deceased, right?
the deceased.
Actually. His diary has been received.
Some witnesses statements are there. Yes, he tried to blackmail the deceased lordship by demanding money.
Peruse the relevant portions of the case there, including the statement of the present petitioner. In the given facts and circumstances, I allowed a bail petition and accordingly, accused so and so is hereby allowed to go on bail of rupees 20,000, 25,000 with one security subject to the condition. Operate with remaining investigations and hamper or temper. So,
Deeply obliged, Your Worship.
May please, Your Lordship. Lordship, this is second bail application, Lordship, earlier rejected. Lordship, on 12/12/2024, Lordship. Petitioners were arrested on 14/11/2025. As on today, they are behind the bar for 54 days. And the statutory period is 60 days, Lordship. Maximum punishment is, Lordship, 7 years under section 3082, which is extortion, Lordship. Lordship, may kindly see the FIR at page number 12.
just a minute.
Earlier order, Lordship will find it.
Yes,
page
sir,
number-
I've seen. I've seen. Yes, yes. What do you want me to see this time? Page?
Page, Lordship, 12 is the FIR.
Oh, yes. Some
Ele-
tea garden, some.
Yes, Lordship, they were shown some
fraudulently,
gardens, Lordship.
something. Anyway,
And then Lordship, they were kept in a room, Lordship. Their belongings were taken away, Lordship.
right, investigation, how much? it
Lordship,
has
yes,
progressed?
CP has gone through by another full deep basis. You are not. I'm informing him. But I am informing him, Lordship.
After a little while. I see. Yes.
Yes, length of detention, Lordship, and Lordship.
Yes. So,
Emphasizing.
rejected on 12/12. And
Yes, my lord,
the
12/12.
Investigation after that, you can see.
My lord, after 12/12, my lord. Yeah, my lord, that is, we received, that is the CD on 11/12, my lord. So it is rejected on, my lord, on, my lord,
12/12, next day.
12/12, next day,
12.
it was rejected, my lord. So, my lord, it is available up to, my lord, 25/11. So my lord, updated city in this case,
To that CD was called for, Lord, from
My
that
lord.
provision.
that is required, my lord. Maybe my lord, matter
Now-
maybe
now,
fixed
Lord,
on my lord, that is the Thursday, my lord. Because otherwise, my lord, that is the allegations are very serious, my lord, in this case. my lord.
That
54 days, Lordship.
day after tomorrow, will you get back the
My lord, on my lord, yes, my lord, day after tomorrow.
updated investigation?
Updated, my lord.
Updated CD.
And you'll retain the case diary.
My lord, they may have, my lord, sometimes other also, no, my lord, some, my lord, 2-3 copies they have.
Okay.
Yes, my lord. As per police manual, my lord, 3
Yeah.
copies
True,
used to they have, my lord. So, my
So,
lord, we make a communication. Otherwise, my lord,
Okay.
here in this case, my lord, that is a allegation is very serious, my lord. Very serious allegation
Acha.
in this case, my lord. And my lord, they are, the accusation is that, my lord, they said, my lord, as part of my lord accusation, they came for my lord, that is of the my lord buying of the tea. Buying of the tea, and second part is that the betel nut. Now, my lord, when my lord, from the investigation, it reveals, though my lord, there is one thing is that some photographs were there, they are taken, my lord, to one my lord place, my lord, where my lord, they were my lord restrained, and they took a photograph along with my lord fake currency of 15 lakhs of rupees, my lord. Now, during the course of investigation, my lord, till my lord, that is my lord, that is 12, my lord, when my lord, it is rejected, my lord, 12/12/2025, it shows something different. Their statement, they shows they know, they are coming here, but not for buying goods. For buying, my lord, that is the fake currency.
okay.
Till then, my lord, so my
Statement
lord, the allegations are so such serious in nature. So I pray before your lordship, my lord, we will take my lord, and otherwise, my lord, maybe some other development may be there. So we'll take instruction and matter may be fixed, my lord.
Additional, the learned Klassen learned petitioner council submits that he's at this stage in the subsequent petition from I seeking bail mainly on the length of detention. The learned additional PB, the voice submits that no case diary has been received, but it is updated only till 25.
My lord, 25/11.
25/11, and considering the serious nature of the allegations, perhaps up-to-date status should be asserted and praise for fixing the matter on
Day
8.
after tomorrow. 8.
Praise allowed. Yeah, what should I say? You retain the case diary?
My lord, either we will only my lord prayer is updated CD, whatever maybe the updated CD on my lord.
The updated instructions regarding
Updated CD or
regarding
any
the,
instruction. my lord.
latest status of investigation
Investigation.
and good stuff while retaining the case diary.
My lord, not exactly.
I won't say.
that
This is the matter
require
of
my lord.
8-1.
8/1.
8-1.
My lord, can my lord 9 will be difficult, my lord.
9 will
This
be
matter.
difficult last day. 8.
Then
Lord.
8,
I can fix on 9 also.
8. Lord.
9, I have not fixed much matters.
my lord. Then my lord 9, my lord. 9.
Oh,
9.
okay.
9.
Nine.
To 9. Give 3 minutes. Oh, hold on. 1.
May I please, Lord? My lord, 483 application, my lord, FIR page 6, Mr. FIR page 6. May I read, Mr. Kiman it? It is item 24. Respectfully, I beg to state that on 18/11/2025, at about 5:30 PM, one vehicle bearing number so and so speedily came and intentionally hit an e-rickshaw at Goroimari Tinali. One passenger of said e-rickshaw, namely Chandra Kaman, injured seriously, and the vehicle number so and so fell down in the drain. 2 thieves were caught with the help of local people, and 4 other thieves were fled away from the place. Presently, Sri Chandrakanta Kaman is under treatment in AMC. My lord, this was, my lord, the allegation, my lord, and police. This FIR was filed, my lord, 19/11/2025, my lord, and the present petitioner was arrested on 18/11/2025, my lord.
18/11.
18/11.
80, huh?
We have not received the case diary.
Okay. He was arrested on 18/11.
My lord, the first day,
On the first day. No,
on the
no.
date of offense.
Fire was lost on the next day.
Yes, my lord.
He was arrested after before the FIR.
My lord,
After the
seems
incident.
like this, when the incident took place, local people, when caught them and handed over to the police.
They have to FIR loss.
Yes.
Day after that. If
Yes. So,
Diary.
So they not received 49 days in custody as even today.
49 days custody, my lord, and the statutory period is 60 days, my lord.
It's from Boginodi, Lakhimpur. Statutory period is 90 days.
See,
1182 is there. Previous one, 320.
118, my lord, is not attracted. No dangerous weapon is here, my lord. FIR clearly shows.
Accused was arrested. One accused is stated to have been arrested on 18/11/2025. Stop. The allegation in the FIR is that on 18/11 in the evening, one vehicle, 8 AS02T 7190, with stolen goods came speedily and hit an e-rickshaw at Goroimari Tiniali, during which the passenger therein, Chandrakanta Borman, was seriously injured. And the two FIR named accused persons were caught by the local people, and 4 other persons involved in such thefts fled away from the place of occurrence. So, the case diary is, the petitioner is case diary is not yet received. Issue reminder. We can fix it on 9th at best.
Not
Schedule. 9/1. 9/1.
Actually, my lord, is 59 days has 49 days is in custody,
Let us
my
see
lord,
the
is
diary.
60 days is mandatory period.
Let us see the diary, and that's why I'm fixing it on 9/1. 9/1 for this day.
25.
25 can be after sometimes, my lord.
So we have not received the case diary. Because earlier,
Today is 57 days in custody and statutory period is 60 days. And this is second time bill application.
Same thing,
Yes.
57 is last on 9th.
He's suffering from big pox in the inside the jail That is why second bail application is filed immediately so that he can get relief
Earlier bail was rejected
Yes,
by.
earlier bill we have annex lordship will file at page 29.
The learned council fairly submits that this is a subsequent bail application. As an earlier bail petition was rejected on 12/12/2025 in BA 3910 of 25. The case, the updated case diary, however, is not received. Should remind list on 9/1.
9 minute. Oh, oblige.
Might be lost.
Can copy of anything?
is here.
Might have the 302 charge sheet file and part charge sheet. And I am basically on length of detention, my lord, investigation already completed, and 47/48 also, my lord. On both land dispute, on the face of it, a land dispute, my lord. Both the parties, cost case also there, my lord. So it is admitted, my lord, occurrence is admitted.
Scan copy of trial court records call follows. That is not received.
Not received.
But your lordship may go through the 47/48, but if your lordship satisfied, my lord, then the scan copy may not be required also. Kindly see page 63, my lord, on what? Total 8 petitioner, page 63 on what?
It is Buragaon, no? Morigaon. Suppose we are unable to dispose of today on the basis of, because if there are several persons, again, we'll have to
Yes.
cross check.
Yes.
Can you get it on day after tomorrow on Friday or Friday?
Okay.
Preferably day after tomorrow.
For registry, will call lordship pen.
Yes. Huh? Anyway, let us
The
see.
scan copy may come, my lord.
What is the, I can see now.
Yes, 63, my lord, page 63.
63.
On what?
63 onwards.
Yes. Barnacular is your lordship will find page 64. Both we have given translated copy as well as that one. Simply they have given a ground, my lord. You also got it, page 63.
Yes, yes, I've seen. On
You are
fire-
hereby informed that you, that is 47. That you are under arrest in connection with the above reference case is non-bailable to the
Sorry.
police, so you are forwarded to the court. You may submit a petition before the honorable court of your bay. Arrest have been made on the following grounds. That you have been arrested as you have conspired murder and assault of the victims. You have been arrested as you were directly involved with this. All the are same, including 48 also, my lord. Same thing. Full description for particulars must be, your lordship is becoming aware of that one.
Anyway,
Huh?
Scan copy was called for. As the case has been charge sheeted. Upon completion of investigation, scan copy of the case diary and charge sheet was called for. The concerned case, that is Huragaon PS case number 49 of
Now it will be
2025.
Sessions case, my.
In bracket, sessions 154 of 2025. From the court of the learned session judge Morigaon. However, the same is not yet received. Issue reminder. This is the matter on when should I fix it? Day after tomorrow or on
Day
Friday?
after tomorrow, I don't know, if possible.
Day after tomorrow.
I can fix it, but whether it will come or not, that's the thing.
That will call for a registry and urgently it was called for.
Already more than 4 months, my lord.
My lordship can do a issue reminder, otherwise.
They're in custody for 4 months.
4 months.
Yes, my. And investigation already completed, man.
Day after tomorrow, 8-1,
Only registry may.
Registry.
to the registry. Registries and do the needful.
Obliged.
Very please, your lordship.
52 টা নেকি?
পিছত আহিব কৈছো।
Oh,
52 কেনেকে আহিছে? This is বেলেগ case.
পিছত কানেক্টেড হলেও তুমি নম্বৰটো আহিলে আহিবা।
আপুনি হেৰি কৰক না, মোক মাতিছে অলৰেডি।
মাতা গৈছে ন? Lordship,
Yeah. 50. 28 and 58. Same. Yes, sir.
Lordship, kindly come to page 9. On the
9.
9, Lordship, that is FIR. And on the last date fix, your Lordship call for the case diary as per my information from the learned additional PP. He received the case diary, Lordship. And Lordship, what happened? The petitioner before your Lordship, he is the cousin of the informant, Lordship. He is a 25 years old boy. And since the interior of the house of the informant was decorated, actually he took some photographs, video of the interior. And ultimately, unfortunately, that video got viral. And Lordship, that video may have been received or got by these accused persons, other accused persons. So they took advantage of that video, Lordship, as per my information and instruction, Lordship. So he is not at all involved with this case, Lordship. He is the cousin of the informant, Lordship. So what happened, Lordship? And Lordship may kindly come to page 20. Page 20, Lordship. He was also taken by the police for police remand for 3 days, from 3rd December to 6th December, Lordship. So he was thoroughly interrogated by the police for 3 days in the police custody. Thereafter, he was remanded to judicial custody on 6th of December. That is, till now, he is 34 days in custody, Lordship. 34 days. And Lordship may kindly come to page 16, Lordship. That is the forwarding report.
Yes.
May kindly come to ground of arrest, page point number 3, Lordship, ground of arrest. Some stolen property have been recovered from their possession and duly seized from their
possession. Lordship got it.
Mm.
So therefore, Lordship, my humble prayer is that since he was thoroughly interrogated in police custody for 3 days, then 34 days in judicial custody, being the cousin, Lordship, 25 years of age, he is not a criminal, Lordship.
Mm.
So he may be allowed to go on bail, Lordship, already 34 days. And he is a student, Lordship, he is 25 years of age, Lordship.
Forwarding report also it is mentioned that he's the cousin.
Yes, Lordship.
So that's
It-
why
it
they
is
want to,
mentioned, yes.
they want to explore motive,
Oh.
his cousin.
So that he is the cousin, that is ground of police remand, that is point
Mm.
number 5.
Uh-huh.
To explore there, yes, Lordship got it.
Uh-huh.
He is the cousin, Lordship. I am only for him, Lordship.
Okay. And
It's sufficiently interrogated, His Lordship.
So going to the case diary and the statement of the witnesses and co-accused, Lordship.
Hmm.
The petitioner is the main mastermind of the committing the Dokaiti, Lordship.
Hmm.
He planned and executed the he is the cousin brother of the complainant.
Hmm.
And he went to the house of the complainant house and that earlier that night, Lordship.
Hmm.
And take a chance of their some from domestic discussion, take a chance to take a glass of water. He made some poisonous substances in their food, intoxicated foods. Thereafter, they have felt unconscious in the morning time and they have planned and they executed the Dokaiti with some sequence. And he had earlier also he made some videograph on the whole house. Yes, and send it to the miscreants, Lordship. And he also in his confessional statement, he also stated that yes, the main person. And the co-accused, arrested co-accused who has committing the Dokaiti, they also said yes, that Chandan Das has planned and
Any 164 statement is there? Any 164
statement of one person is there, is the goldsmith, one who bought the ornaments from Sahijul Lolam and Mubarak, who executed the Dokaiti, Lordship. He bought the ornaments on 2,25,000.
Can I have it?
Lordship. 164 statement, Lordship.
And the other bail you are appearing? You are
I
appearing.
am appearing in item number 58.
What about the other person? Other bail?
Lordship,
He's one of the, he's
He's
one of the persons named in the
Yes.
forwarding report. Mubar Ali.
Not in item 58, Lordship. May I, Lordship, refer one page, Lordship. In this case also, the prisoner was under police custody, Lordship. From 5 to 3 or 4 days, Lordship. He was subsequently produced, Lordship, on 9/12. Lordship, as per ground of arrest, Lordship, he was not involved in the incident. Allegation, if you, Lordship, kindly come to page 14. Ground number, Lordship, 2, 3, and 4. That he, Lordship, has facilitated to conceal the accused. That is the allegation against the present petitioner. Lordship, page 14.
Yes, during investigation, it was
During
revealed that
investigation, it has come to light that the arrested accused person helped in concealing the accused person as well as other stolen property. The arrested accused has fully knowledge about the crime that have committed by their gangs and he deliberately helped them to evade them from police. This is, and Lordship, your Lordship may kindly come to page 16.
Yes.
Notice, Lordship, that is given with the same ground, but in English vernacular, English. But your Lordship will see the signature of the accused person. Mubar Ali. He do not know English. Lordship, in that,
There is
that
a
effect,
mention,
Lordship,
there's a mention here. So anyway.
he has fully knowledge about the crime and Lordship helped the accused person to escape from the police. And due to his stolen properties, yet to be recovered, some of the stolen properties, and some person yet to be arrested. Lordship.
but how he was involved, because he was not in the incident, Lordship, while committing that incident, Lordship.
He was subsequently arrested.
Yes.
First four, then these two.
My lord, I am
He is giving the shelter to the as the accused lordship.
my lord, just one judgment lordship in Mihir Rajesh Shah, another Supreme Court lordship, latest judgment lordship regarding the ground of arrest lordship.
No, but it is mentioned here, it has been explained to him.
Yes.
You should be realistic also, isn't it? Otherwise, how will you?
My lord, just
rank-
tick marks
Yes,
lordship I have
I-
given.
And the language he understands.
Which I have fragment of relevant portions in the investigation part also.
The written form, the writing of the grounds should be in the language of the language understood by the, if that is the thing, then otherwise it will mean substantial compliance also. Anyway, it depends also, you know. Generally, this is okay. He has to understand, of course, otherwise how will he defend?
He was
Just give me
not
once.
involved in the incident lordship.
The investigation indicates otherwise.
Already
This is your instruction, but the
4 days
investigation-
lordship, he was in police custody, lordship thoroughly interrogated. And a list article have already been recovered from other accused lordship.
He was arrested on which day?
I am arrested on lordship 4/12/2025. 34 days lordship.
This, I'll have a look. Give it to me. Sir, Rico, here, Mr. Learned Counsel for the petitioner and DP person. 483 bail application. Abhayapuri case number 265/25. Under so and so section. The accused was, the present accused, Chandan Das, was arrested on 3/12/2025 and presently in judicial custody. FIR was lodged on 29/11/25 by Aday Shankar Das with the allegation that on in the night on 26/11/25 in midnight around 12 AM, after he and his family members had gone to bed, some miscreants broke open the door and entered and sprayed some substances, making the family members unconscious, and thereafter committed robbery in their house, taking away gold ornaments, cash, etc. The petitioner was arrested during investigation, and he stated to be the cousin of the informant. It is submitted by the petitioner, learned petitioner counsel, that the petitioner had worked on some interiors of the house of the informant, and but during which he had taken some photographs, and unfortunately that photographs became viral and fell into wrong hands and was misused to commit the alleged offences. It is submitted that the petitioner is not at all connected with the said offence, full stop, and that he has also been in custodial remand, police remand for 3 days, during which he has been thoroughly interrogated. The case diary has been received. Full stop. It is submitted by the learned additional PP that the present petitioner Chandan Das is stated to be the mastermind of the alleged offence, and taking advantage of his proximity to the family as a relative, he along with the other accused persons, committed the robbery, dacoity / robbery at night. Full stop. Stolen property has been not recovered completely.
Some of the sums are recovered.
The stolen property
Other
stated
parts are
to
yet
have
to be
been
recovered.
partly recovered. Way to conclusion will be same. This case, the present petitioner was arrested on present petitioner Mobar Ali was arrested on 4/12/2025. It is submitted on his behalf that he is not involved, and he has after his arrest, he has been in police custody for 3 days, during which he has been thoroughly interrogated. Full stop. It is also submitted that the grounds of arrest have been furnished in English language. I have perused the copy of the notice under 47/48 with regard to the accused. There's a noting of the IO that sufficient knowledge of the basic facts constituting the grounds has been imparted and communicated to the arrested person effectively in the language he understands. We can explore it. Good stuff.
One of the statement of he helped to sold up ornaments to that one goldsmith.
The learned additional PP submits that investigation has revealed implications against the present petitioner as being involved with the other persons in the alleged offences. And more specifically, the investigation has revealed he helped the other accused persons to sell the stolen jewelry to some goldsmith stuff. Same conclusion. Considering the nature of the alleged offences, the adverse materials revealed, in fact, that investigation is still in progress. The instant bail petition stands rejected at this stage. Return back case diary.
Is a search circular.
Just a minute. What is it? 58. I don't need to find.
29.
Charge sheet submitted.
Yes, Lordship.
What is the matter otherwise?
Subject to go to the lawyer.
Assault.
Charge sheet.
So. Who is the FIR?
FI is in case 17 Lordship. Assaulted by using some sharp weapons. Assaulted by using some sharp weapons.
It was what is connected bill application? There's a note of registry. Yeah, there's a note of registry. It was the bail application of 3 other persons who was taken up by Ayub Khan, Alima Begum, Khudeja Khatun.
Yes, connected.
It was rejected by Fugan sir.
Oh, then
Fugan sir. But the note was put up before him, but nothing. Would you like to have a look?
yes.
Maybe we can. He is on a different list. Direct it to me. Just a minute. Not complete. Not complete. We are just ascertaining something. The present petitioners are, who are the present petitioners? Their names are Abdul Barak.
Abdul Barak, yes, Lordship.
Earlier, 2 orders are there, also that to the appropriate bench. That's why appropriate bench, because the earlier rejection order was by,
Not with regard to them, with regard to co-accused.
but FIR is same.
FIR is same. Same persons or co-accused, other co-accused. The two rejection orders are with regard to these two petitioners only or some other, just cross-check them.
Two petitioners.
Abdul Barik and one other.
Other three are the Ayub Ali, Alima Begum and Fudeja Khatun.
That is one rejection.
And other is Muzammil Haq, Tanzmul Haq and Sadijul Islam. Same case is Sapor PS case number 198, case is same.
Appropriate bench only.
Okay.
Better. Case diary has been received.
No, the charge sheet subcase.
Charge sheet submitted. Appropriate bench.
Yes.
Okay. There was the office note dated 4/4/2025. In this case, in the meantime, the investigation is stated to have been completed, resulting in a charge sheet. BA 3968 of 2024 and BA 250 of 2025 pertaining to co-accused of the same PS case, that is Sapor PS case number 198 of 2024, were disposed of by coordinate bench. This is the matter before the appropriate judge. Should I give a date? No, I can give a date. Day after tomorrow. 8. Come, automatically.
30.
May I please, your lordship, earlier honorable court granted interim bail.
Yes.
And petitioner appeared before the.
Appeared.
AO.
Hmm.
And his name is not in the FIR, he is only the cousin of the accused Samina Begum.
Yes.
Here, my lord, as stated my learned friend, my lord, her statement is available in the diary and that is this, her cousin, my lord. She is already arrested, my lord, from the residence of the present accused petitioner. That statement is there, my lord. And they, my lord, file one, my lord, that is bail objection, but that bail objection is related to other not along with that, my lord. Otherwise, her statement is there. And Subena's statement also recorded, both these two statements.
What happened actually?
Actually, my lord, there is a theft committed, my lord, regarding a, my lord, Innova car, which is taken on rent from Delhi.
Brought
to there, then from the hotel room, there's a gang actually. They have taken the thing and the driver, he was slept on 26th of night. That is, it is stated in the FIR that my lord, after taking the meal in the dinner, he slept, and on 31st, my lord, when he wake up in the morning, he found that that is the key of the car is not available, anything there. Somehow he went to Guwahati and thereafter Delhi, then thereafter this FIR is lodged. Is 13 is the FIR, my lord.
Page 13.
My lord, 30,
1-3.
1-3.
The present petitioner is the present petitioner.
Present petitioner is not FIR name. She
Not
is,
FIR name.
Not FIR name, she is Pakiza Khatun.
Hmm.
And from her statement, it is revealed that that is the Subaina Begum, who is the one of the accused who involved in this manner. That is the offense, my lord. She was the cousin of the present accused petitioner.
There are no materials against her.
Yeah, not that part I didn't notice, my lord. Even there is one bail of recent bail objection prayer also they filed. There also they didn't name her. In the very first part of the diary,
Yes, sir.
there's a separate seat is there.
This is not with regard to this person.
Not regard to other three persons' names are there. In the last part.
Okay. Other cases also.
Yes, because if from her home she is arrested, madam. And madam, peruse both the statements also. I have flag mark.
It's okay.
Yes.
She can be her. She's on interim.
Yes, yes.
It can be made absolute, perhaps. The Innova has not yet been recovered.
Not recovered. Not recovered.
Mastermind, so and so, Arif Uddin. You know.
2024 matter.
Just the petitioner was granted. Petitioner Pakiza Khatun was granted interim bail on 10/2/2025. That is court. 234. Stop. It is submitted that the present petitioner happens to be cousin of the cousin sister of FIR named cousin sister of Subina Begum, one of the 4 FIR named accused persons. The case diary has been received and the same is confirmed by the learned additional PP, who also submits that not much, no, you have not noticed, right?
Yes.
That no any significant incriminating material has been noticed with regard to the present petitioner.
Till date.
Till date. Stop. However, investigation is continuing. In the circumstances, perhaps there is no need to cancel the interim bail, and accordingly, the interim bail granted by 10-2 is hereby made absolute, subject to the condition that he shall render full cooperation to the remaining investigation. He shall not hamper or tamper with anything. Return back the case diary, bail petition stands allowed and disposed. Allowed and disposed.
My lord, in both these matters, my lord, I have the instruction that, my lord, perhaps charge sheet has been submitted. On the last occasion, my lord, the learned PP was directed to verify. This 33, 32 and 33.
Allegations are
Attempt to murder, my lord. Lordship had already granted interim, my lord.
I have.
Yes. Lordship granted.
Then we take a instruction, my lord. The instruction we didn't receive, my lord, the 32 and 33.
Medical report was also called for.
My lord, updated CD was called for, my lord, that is not received, my lord. So we'll give a short date, my lord. In the meantime, my lord, we will take.
Both cases, should we fix it after vacation or you want it before, after vacation? The case diary is, updated case diary as called for is not yet received, issue reminder. The petitioners were granted interim bail on 18/9/2025. First of, the interim bail shall continue till the next date of listing. Issue reminder to the list on after vacation.
27, 28.
Or it can be earlier also. It
Minor.
can be, we can fix it on 21. 21 one. This one is also same.
Same, my lord.
Same date, no? Same date. Interim was on same date. 18. Then 21
Minor.
one. 21 one.
Highly obvious.
35.
Copy on this matter.
Fair enough. Yes. it's allowed.
Wait, please, your lordship. The three friends, Lord, they went out. One died of overdose as informed, lordship. That is the whole thing. Page 19 is the FIR, lord. They were earlier in rehab also, now also one of them is again in rehab, lord, out of these two. Page 19 is the FIR.
19. So ultimately, there was, he alleged that he was murdered.
He alleged ultimately it was murder. 29, 30-year-old boy. Paragraph from 4 onwards, we have stated the actual fact, how it happened. We took it from the accused. My lord, other, my lord, Vidara and my lord, toxicological examination report, my lord. It was sent for GMCS, my lord. It was obtained, my lord. No poison was detected, my lord, in the report, my lord.
Now, my lord, what I have found, my lord, in the postmortem report, my lord, there are only some radius contusion in the, my lord, forehead, my lord. Contusion, my lord. And
Intake of drugs, nothing.
my lord, the drug, my lord, that has
Poison
not-
does not-
poison has not been found in the substance, my lord, in the toxicological report, my lord. And secondly, my lord, when the FIR was lodged, my lord, on that day itself, my lord, both the accused person's statement were recorded by the police, my lord. This person, my lord. Later on, maybe, my lord, police has, my lord, again, charged them or what, that is not clear from the case diary, my lord. The fact is that they were along with the, my lord, victim, my lord. That is the fact, basically, my lord.
They are not disputing that also, Lordship.
Since there is an allegation of planning, but it may not be true also, but true also. But according to him, it's a different case.
My lord.
Consuming drugs and dying, and then they panicked. And they
My lord.
tried to make confusing
But
statement,
in
confused
their
statement.
statement, my lord, they have accused has only stated, my lord, they consume alcohol, my lord.
Alcohol.
Alcohol.
These 2% drank alcohol, the deceased, he mixed alcohol with drugs, as per my client's instruction block. And all this happened. And it is also not in dispute, all are from rehab, Lord, trying to make up their life. All I have to Lord, is let the report come, till then I will protect it so that my statement be recorded and I may assess the investigation without.
That can be done. That can be done. That may not be a bad idea. Third A law, consequent.
One fact, my lord, I have said, my lord, whether any notice has been issued to them, my lord. No notice has been issued, my lord. But on the same day, my lord, when the
They
FIR
were
was
examined.
registered, their statement also
The two
recorded.
petitioners hearing invoking 482 are seeking bail, anticipatory bail in connection with Sanwari PS 189 of Odisha, registered in the so and so. The FIR dated
Page 19, 21/7.
21/7/2025 lodged by the grandfather of the deceased boy has narrated several facts about the persons coming to his house and going out with his grandson. And eventually, the victim was brought to GMCH and found to be dead and was brought to GMCH dead. Full stop. It is alleged in the last part of the FIR that informant suspects that the accused persons murdered his grandson. It's true. The learned petitioner counsel submits that the accused persons and also the deceased, they were all rehab persons. They were earlier taking drugs and presently undergoing rehabilitation. And on the fateful day, they had taken alcohol, and some of them had mixed. They and other friends had taken alcohol, and some of them had mixed alcohol with drugs. And during the night, the victim was found on the steering of the car with throat coming out from his mouth, and upon being taken to the hospital, by the time he was taken to the hospital, he was already dead. The case diary has been received, and it is submitted by the learned prosecution that the statements of the present petitioners have were recorded on the day of the alleged or day of lodging of the FIR itself. However, he could not find any notice further. The learned additional PP also confirms that these boys were also undergoing rehabilitation. At this stage, perhaps the petitioners, it may be prudent to allow the petitioners to record their version of events before the police with some interim protection while allowing the investigation to proceed further. In such view of the matter, the CD may be returned back and procured again
Up to the
with the up-to-date investigation for the next day. In the interim, in the event of their arrest, 25,000 each, the security of like a mortgage to the satisfaction of the concerned learned court. Satisfaction of the arresting authority and subject to the condition, cooperate with the investigation. They shall appear before the IO once again and make themselves available for examination. They shall not hamper or tamper with evidence. They shall not intimidate or threaten the informant side or any witnesses. This is the matter on last week of January.
28
Yeah, 28, 29.
I'm
28
okay.
1. Okay.
May I please, your Lordship? Lordship, this is a pre-arrest bail application, Lordship. In this case, Lordship, FIR will find case number 13, Lordship. And only the statement is given by the other co-accused, Lordship, and some golden ornaments has been given to the accused person, Lordship, that is accused number 1. And only this line is against me, Lordship. Others, Lordship, some ornaments has been recovered from the offended accused and he is already been granted bail by Lordship. So, my Lord, and let me, Lordship, and I'll cooperate with the investigating agency, Lordship, and maybe give an opportunity to give my statement, Lordship. Nothing has been recovered, Lordship. Recovered already from another person, Lordship. Only one line is against me, Lordship, and already been recovered, Lordship. And FIR lodged by the police, not by any individual person, Lordship. And the local person, Lordship, they might have their statement has been recorded by the IO, Lordship. And if anything is against me, Lordship, that may be, Lordship.
Yes.
So far, I remember, my Lordship has gone through this case diary, my Lord. Several articles were recovered, my Lord, from the position of one Sahejul Hussain, my
He has
Lord.
been granted bail.
Lordship.
He has been granted well from his position, my Lord. Several, my Lord, gold articles, my Lord, earring, bracelets, etc. My Lord, that was recovered, my Lord. Now, my Lord, I have perused the case diary, my Lord. My Lord, he has, my Lord, the accused person, my Lord, arrested accused person, whom was
I got to find first. There are 2 and 3. There are 2 and 3. Mr. Hawk, Learned Counsel submits that the only implication against the present petitioner is the statement of the other FIR named accused, Sahejul Hussain Saikia, who has been granted bail by this court on on 19/12/2025 in BA 3977 of 25. The present petitioner is also named in FIR and is stated to have, and as per the forwarding report of the other co-accused, he is stated to have given the jewelry to that co-accused, who was subsequently granted bail. The case diary is in receipt and learned prosecution, Mr. Borua, learned additional PP fairly submits that so far, apart from the said statement of the accused was arrested, there's no other materials has come to notice.
investigation is still pending, my Lord.
No other
Only, my Lord,
incriminating materials has come to notice. However, investigation is still in progress. In the given facts and circumstances, I deem it proper to allow this bail application and accordingly directed that 30,000 with one sealed, the satisfaction of the arresting authority, subject to the condition that he shall appear before the IO and make himself available for examination. He shall not hamper or tamper with evidence. He shall not commit any illegal activities or offences. Return back the case.
Deeply obliged. Deeply obliged. Obliged. Timing again.
You want to pick up this one?
May I please, Your Lord? My Lord, here, my Lord, with all respect, my Lord. My friend has also filed a counter, my lord. That bail need not be granted, my lord. Here, my lord, primarily Section 7, my lord. There, my lord, what has happened, my lord? CBI took two views, my lord, in black and white, my lord. Hence, the bribe giver, he has been granted the privilege of bail, my lord. And one place it is stated by the CBI that, my lord, he was caught red-handed. And in another place, with all respect, my lord, it has been stated that he was waiting outside, whatever be it, my lord. And on that count, the bribe giver has been granted the privilege of bail, my lord. And thereafter, my lord, regarding this man who is in custody, he is neither the bribe giver nor the bribe taker, but, my lord, allegedly, my lord, the sections of law attributed, my lord, he being in there in the management, my lord. And certain phone calls were intercepted. There is 2 lines are apparent, my lord, which is
Before
part of the
proceeding further,
record.
just 1 minute. Before proceeding further, it's my duty to ask this actually. That since I think his anticipatory bail was rejected.
By your,
by
that
him,
way
and
it has come
So
before. you.
therefore, would he like this matter to be, taken up by another criminal bench? I think, because just for his satisfaction. For his satisfaction, personal satisfaction.
We
No,
have
you want-
such problem.
No,
If your
not me,
lordship.
actually, petitioner's side. If you want, I can, then it can
No,
be fixed
I have-
tomorrow.
I have no
Before
as
another
such
criminal bench.
reservation.
So, as your lordship, please, I have got nothing to do.
Because that will be, for his satisfaction. This is also, important.
It is
My
up to
lord.
them.
Because he may have some bias, since earlier it was rejected. This is a maybe.
AB.
We'll look at it objectively, of course, but the thing is that.
But we, from our side, there is
No,
nothing
yeah,
as such.
as a seasoned counsel, you may not have, but I think we should also think about him.
No,
No?
but I have no as such reservation.
Yeah.
Your lordship can take up the matter.
No, that's not.
It is up to them.
No, it is
because
not, I also feel, my lord, but as your lordship, please.
Yeah, I think it will be better. Let it be posted before another another coordinate bench taking up criminal matters. And fixed tomorrow. Huh?
Highly obliged, madam. Obliged, madam.
Tomorrow.
IV 35.
May I please, the lordship, 482 application has sent. There are 2 petitioners. Petition number 1, she is on interim bail and her statement has been recorded, and number 2 is her son. What happened in this case, FIR, you'll also find it page 14, you'll also find. Regarding embezzlement of money, the prime accused Sanjay Tamal, he has already been arrested. He is the son of petition number 1 and brother of petition number 3. Some of the amount were transferred to their accounts, and again it was taken back by him. So they have also been implicated along with the prime accused. Prime accused, he has already been arrested on 28/10/23.
He's in custody.
No.
He's in custody.
He is in custody. Prime accused, Sanjay Tamali. He had a mother and a brother. What happened? Some amounts were transferred to our account. And mother's account, he himself used to operate the same. So mother was not aware from where the money came. And regarding brother also, he thought that some investment amount was given to that account paid. And again, that amount was taken back by the brother. That's some of the legacies we have annexed. So they still also will see the case there.
No, this is a voluminous case there, my lord. So, my lord, I beg to my lord, place this, my lord, bail objection, my lord. Where is my lord? In a nutshell, my lord, I have reflected what has been found in the, my lord, during investigation, my lord. Against the both accused number 1 and 2, my lord. It doesn't work.
Petitioner number 1 and 2.
Petition number.
Against the petition number 1 and petition number 1 is on interim, my lord, and she has appeared and her statement also recorded, my lord.
Both the petitioners were not given interim.
No, only one was given.
The
Two
above named accused petitioners shall be allowed to go on bail. It's written like that in the order. Above named accused petitioners will be allowed.
That most, while in court, only one was granted. The lower person most probably also will find.
Order to him, my lord.
Order to see. Petitioners বুলি কৈছিলে এটা হা কিন্তু কোৰ্টে কাটি দিছে
Actually, the audacity are also fine.
Uh,
In para six, petitioners were there, but in the condition, petitioner is there. The petition shall go by, not petitioners. And the court also stated in the court that only one I am granting.
Their arrest, it is written their arrest. In effect, it has become for both actually. In effect, it has become for both.
Let it, then, my lord, let the matter be placed before the death bench, my lord, wherein would, to clarify, my lord, whether it is given to one and
We are under the
both
impression, that's why.
both the petitioners or
Fairly
one.
committed. No, that can be done. Better,
My lord.
let that court dispose it of.
Yes, my lord,
That can be done.
There was the previous order dated 12/11/2025. Earlier order dated 12/11/2025. Shall be listed. The matter may be, case diary has been received along with a bail objection. The matter may be listed before appropriate bench.
my lord. That has to be mentioned, my lord, otherwise, my lord, it will not go, my lord.
लिखी दी वहाँ इसके सब इसके सब
Fix a date.
yeah so it can be I can fix it tomorrow, but tomorrow there is a reference.
No, then they have to.
But tomorrow, but that matter also I mentioned
After
that
the
tomorrow.
opening of the big vacation. After the opening,
After can as you
if the
wish.
bench is available.
Because we actually don't know, it keeps on going.
Let it be day after tomorrow, my
Day
lord.
after tomorrow.
They have to.
Not
This
only,
may
my lord,
be
that
good.
fact, my lord, if it is interim is granted to both, my lord,
Uh-huh.
then he should also appear, my lord, pursuant to that.
That
order.
part will be there.
So
So,
in effect, it is both only, I think.
My lord.
In effect, it becomes a both.
no,
But I don't know.
but that's why.
Otherwise, you'll have to be changed.
Much.
39.
May I please, Lordship?
Yes.
Lordship, kindly peruse the FIR, Lordship. FIR page number 10. Lordship, this is section 302 of IPC. The Lordship, kindly peruse page number 13, Lordship. May I read, Lordship?
13, right?
Yes, 13. Lordship, on the 21/2023 at about 6 p.m. in the evening, the above named accused persons in the pre-planned manner and the conspiracy called my husband Sirajul Islam and the two Siddiq Market. From last few days, the land dispute was going on between my husband and the above named accused persons. As soon as my husband Sirajul Islam reached in front of the pharmacy shop of the Motiuddin at the Siddiq Market, the above named accused the number 1, the Basirul Islam, accused number 3, the Arfan Ali, accused number 4, the Rubul Islam, accused number 5, Azizur Rahman, and accused number 6, Habibur Rahman, stepped my husband from behind with a sharp weapon, the like dagger. And he is in order to save himself went to the computer shop of the Soriful Islam. But the above named accused person again stabbed my husband on various parts of his body and caused the grievous injuries. As a result of which my husband soaked in blood and fell down in the place of occurrence. Though the witnesses who were present, they are informed the family members and they took him to Rupohi Hat Model Hospital for treatment, but the doctor suggested to take him to Deaf Care Hospital Nogam for the treatment. And while undergoing treatment at the Deaf Care Hospital, my husband died. And the Lordship, in this case, Lordship, the main accused person, the Basirul Islam, who was arrested, and the Lordship, now he is on bail. And the Lordship, the police, now the police has filed a charge sheet, Lordship. And the Lordship police filed a, though Lordship in the affair year 11 accused person, the police filed a charge sheet against 7 persons, the 7 accused person. And the Lordship, the main accused person with the Basirul Islam, and the Orphan Ali and the Rubul Islam, who were arrested by the police, they are on bail. And the Lordship, in the affair, Lordship, the incident occurred in front of a pharmacy shop of Mofizuddin. And when the victim tried, the diseased person tried to save his life, he entered into the computer shop of the Soriful Islam. And the Lordship, they were recorded their statement under section 164. And the Lordship, thereafter Lordship, the accused, Lordship, accused Azizur Rahman and the Habibur Rahman, they filed an anticipatory bail before the High Court, and their bail application was allowed, Lordship. Lordship, I want to submit that bail that order, Lordship. And the Lordship, the pair number 8 of that order, Lordship, it is important, Lordship. Because Lordship, the witnesses whose 164 statement was recorded,
They have only named the main accused, the Bosirul Islam. And the pair number 8, Lordship.
Madam, scan copy of the record has been called for, madam.
Yes, sir.
And I failed them the scan copy of the record, madam. Not been able to go through, madam.
Just
Scan.
But the 164 statement was recorded, but they have taken the name of Bosirul Islam. And the main accused, the Bosirul Islam, that he stated that there was nobody with him when he assaulted the deceased person. The Lordship, only on the basis of the suspicion that my name was mentioned in the charge sheet and the FIR, Lordship. And the Lordship, this case is pending now before the CJM court. So Lordship, I may be protected till I appear before the session court, Lordship.
It's pending before the Sessions Court.
No, Lordship, the CJM court, Lordship.
CJM.
Yes.
Still in the command of appearance stage, my lord. Not been committed.
Yes.
Lordship, we may be protected till I appear before the session court, Lordship. The Lordship, at that time of incident, I was not
Kukri
here.
was found. Anyway, that is the weapon of. There is 164 statements. One is I found. And have a look at the 164 statement. Yeah, the learned judge in this other AB pertaining to other persons
My lord.
has referred to
The
this.
question is that, my lord, in the
164
charge sheet, my lord, they have been shown absconder, my lord.
Absconder.
Yeah, it's a case of, my lord, 302, my lord. My lord, I may be allowed to, my lord, go.
You can have a look at quickly flick through the 164.
My lord.
But Lordship, in the charge sheet, Lordship, there is no allegation. Lordship, in the kindly period, last pair of the charge sheet.
Scan Google Group.
Kindly go through the 164. Third, Deori.
Yes, sir.
And it comes, Ajay Polo. 482 bail application. Rupohi Act was case number 33 of police. Within bracket PRC 441 of 25. Under section 120B, section 302. The case is stated to be at the stage of appearance before the learned CJM no. And in the charge sheet, the present two petitioners have been indicated as absconders. 11 accused persons were named in the FIR dated Lease Act 2023 with the allegation that between the accused persons and the informant husband, Sirajul Islam, some land dispute was going on, and on the fateful day, a planned conspiracy was called to a market where he was assaulted by accused number 2, 3, 4, 5, and 6.
Yeah, but
And
the
when he tried
161,
despite his trying to escape, he was again assaulted in various parts of the body. And though he was taken to hospital, but he died in hospital during treatment. Yes. Yes, tell me.
yeah, but the 161 statements are not available, my lord. 161, only my lord 164
164 statement.
64, my lord, they have not implicated, my lord.
Not implicated.
Not implicated. 164.
That we don't know. But otherwise, the allegations are very serious.
Allegations are very serious, my lord, and they have been shown as absconder in the search, my lord.
Yes.
What a role. Lordship, there is no role of the present petitioner in this case, Lordship.
That is true, but that is your submission, but you have to cross-check it.
Yes, the 161 statement we have to go through now.
The petitioner counsel submitting a copy of bail order dated 25/4/2023 passed in AB 1242 of 23. Has drawn attention to para 8, in which the court, after referring to the statements of two witnesses under 164 CRPC, has observed that those statements do not implicate the two petitioners who were before the court in that petition. And also observed that the witnesses make allegations against one Basirul Islam. Full stop. The petitioner has also submitted that out of the FIR named accused persons, the said Basirul Islam, Arfan Ali and Rabul Hussain have been granted regular bail. Stop. The learned additional PP, after perusing the aforesaid statements available in the scan record, also confirms that there is no implication in the said statements. However, it is submitted that the components of the case diary, including components of the case diary pertaining to police statements, are not available. So shall we call for that? It will be better to call for that.
Yes, but it will be appropriate, my lord, since they have been shown as an absconder in a search sheet, my lord. So on what basis, my lord, they have been implicated, my lord, that has to be looked into.
Otherwise, but lordship, there is no role of the present petitioner's lordship. Because in the search sheet, the police have not stated anything against us. But kindly peruse the search sheet, the last pair. Nothing in the search sheet and the affair lordship.
Allegations are very serious.
But the lordship allegations are serious because lordship, initially lordship, the affair was a loss against the 11 accused persons. Then the police filed a search sheet against the 7 accused persons.
All the other accused persons are on bail now?
Yes, lordship.
All others?
Yes, lordship.
No, they are on regular bail, my lord, but this is an anticipatory bail, my lord.
True. Let us call them.
Yes, ma'am. 1617 may be called.
Lordship, I may be protected lordship till I appear before the session court because lordship, I have to any role in this case, lordship. I was not present when the incident occurred. Even lordship, in that bail application, lordship, pair number 8, the learned our High Court already said that the prime accused Basirul Islam in his statement before the police does not incriminate.
All are not on regular bail. Sorry, to interrupt you. All are not on regular bail. These two are on. They were given anticipatory bail by this by the court. You know.
Yes.
Ajijur Rahman and Habibur Rahman. Anyway.
Because lordship, in this bail order, lordship, it is clearly stated that the prime accused Basirul Islam in his statement before the police does not incriminate the petitioners and instead that there was nobody with him when he assaulted the disease.
Mumtaz Begum and Anjuma Minara, they were granted bail.
No, lordship, the search was not filed against them.
Oh, no, it's not against.
Against Mumtaz Begum, Anjuma Begum, Minara Khatun,
Against
and
only
the
eight persons.
Yes. The lordship search sheet filed against 7 persons.
7 persons.
Mane accused person Hassan Ali and the Mumtaz Begum and the Anjuma Begum and the Minara Khatun. The search
It is
was not filed
submitted by the
against them.
petitioner that it is submitted by the learned counsel that out of the 11 FIR named accused persons, charge sheet was submitted against 7, and except the present 2 petitioners who are indicated as absconders and seeking pre-arrest bail herein, the others have already got bail. Three have got regular bail, and the other 2 have got pre-arrest bail. In the entire facts and circumstances, despite the serious nature of the allegations, but considering the stage of the case and the aforesaid circumstances, I allow this bail petition, and accordingly it is directed that the event of 30,000 at one security of the like with the satisfaction of the concerned learned court, arresting authority, and subject to the condition that they shall appear before the learned court below, shall cooperate with the investigation, shall not hamper or tamper with evidence, shall not intimidate or try to influence the informant or witnesses. Violation will entail cancellation of the bail. The bail petition stands allowed and discussed. Keep it pending.
Okay.
Forty, my lord, case diary was called for, not received, my lord.
Bongaigaon appeal. When do you suggest date? The case diary is not yet received. Issue reminder. For city of Bongaigaon, PS 290 of 2025.
9, my lord.
On last day.
9th, my lord.
Fix on 9/1.
Master place.
44.
May I please, Your Lordship? My lord, Your Lordship, kindly see the FIR, my lord. Page 10, my lord. My lord, in the FIR, my lord, as many as 5 persons are named. Already 2 person, accused number 1 and accused number 3 has been granted bail by Your Lordship, my lord. And now, my lord, present petitioner, my lord, 3 petitioner, my lord, FIR named accused number 2, 4 and 5 before Your Lordship. My lord, I have annexed the similar order, my lord. My lord, page, my lord.
Investigation is not completed?
My lord.
Investigation is not yet completed?
My lord, actually, my learned friend has gone through the case diary, my lord. Can it be taken after some time, my lord? That's after.
My lord, page 23 is the order, my lord, passed by Your Lordship, my lord. My lord, prime accused already granted bail, my lord. Now, my lord, the present petitioner, my lord, they are the father and 2 sons. Out of my lord family, my lord, rivalry, my lord, this FIR has been lost, my lord. Otherwise, my lord, the victim, my lord, suicided by consuming poison, my lord.
Only after some time, my lord.
May I please, Your Lordship? Lordship, this is subsequent second application, Lordship. The case diary was called for this case.
Whether received.
Lordship, Lordship will find the FIR on case 13, which is the typed copy, Lordship. May I read the allegation, Lordship?
No, allegation I'm seeing from here, some transportation.
Yes.
Theft or something.
And
right.
the petitioner here are the owner. 2 trucks are mentioned here. And both the owners are the petitioner in this case, Lordship.
A recovery of was made out from the both the trucks, Lordship, from the secret chamber of the truck.
The actual fact is that, Lordship, the driver who was
They are driver and owner, driver and handyman.
no,
They are the owners of the trucks.
These petitioners are the owners of the truck.
Owners of the truck.
Driver and handyman
Still absconding.
are absconding, Lordship. And where the truck was halted, they were brought from a particular place, and the suspected to be Burmese Supari was the state contract was taken by the driver. That is within the awareness of this particular petitioners, both the petitioners. Now the petitioner is not aware who has sold the state Supari and from where and whereabouts of the drivers and the handyman. The sections that are attributed in this case, 303 and 317, whether any witness is there that will attract these sections of law to the present petitioners. Otherwise, the 303 is theft, 317 is 3172 is receiver of stolen property. Lordship, both the petitioners are ready. They know the names, and they do have a copy of their Aadhaar card and voter card of the driver and handyman.
We have to see the subsequent grounds now, right?
Yes, and they can provide all the details to help the investigation.
There's some endorsement in the thing.
In terms of
No, no, in the earlier bail application, there was some submission that investigation has revealed some complicity. That
Yes,
they
sir.
are being transported in secret compartments, which is
Yes.
not possible without the knowledge
Without
of
the
the owner.
knowledge of the owner. Secret recovery from the secret chamber of the both the trucks. And the FSL report is received for 3.
FSL report is received.
Yes. The result of the chemical analysis of the exhibits gave positive test for alkaline, the major alkaloid present in Arakan upload.
The allegation in the FIR, which is also said that it's Burmese or something else, but it cannot be determined through an FSL. I have the substance, it is only a chemical substance, whether presence of certain chemicals are there, that is only determined. And otherwise, the secret chamber, Lordship, that the petitioners can only reveal when they will, when the information they can provide it adequately.
Investigation is not completed.
Not complete, they are divers and handymen are yet to be as that they are absconding. And the documents of they cannot provide any documents, valid documents regarding the seized articles.
Once the opportunity is given, then we are not the owners of the seized articles. We are not the owner. Once the opportunity is given, then we can adequately provide the details, Lordship. The details of the drivers and the handymen. That can be reflected in the order, Lordship.
The only thing is that without the knowledge of the owners, driver cannot make a secret chamber to.
Unlikely.
Yes.
Possible, but unlikely.
But
Unlikely.
the one who owns the LSZ Beetle Nut.
No, but I cannot go into
It
the
could be
very
his,
subsequent grounds only I have to see.
because the truck always goes in and out of the route. And whenever the truck stays out of sight from the owners,
Not
there is a
impossible.
possibility.
Not impossible, but unlikely
Yes.
that he will not know.
And the sections of law that
This is not a
attributed in
regular
this
bill,
case.
that's anticipatory.
Secret bill. So from the custody of the driver and the handyman, their apprehension is very much necessary, but without their cooperation and.
Lordship, a condition may be imposed if the petitioner does not provide the details. IO can anytime approach the court for cancellation of bail.
AB 28 was being within paragraph 234 same about it. The 2345. Earlier bail petition was rejected on 12/12/2025 in AB 2870 of 2025, 2025, 2870. Investigation is still in progress. Case diary as called for has been received. Investigation is stated to be still in progress, and FSL report is available now. And as indicated, what the finding is.
Finding is effective, the major alkaloid present in the recana. Alkaloid present means. 45.
Alkaloid aragonite. The driver and handyman of the trucks are stated to be still absconding. And notice the narration in para 7 and 8, 9 of the earlier order. Stop. The investigation had indicated earlier about the involvement of these offences being executed in a well-planned manner by syndicates. I do not find sufficient new grounds to take a different view in this subsequent petition. Accordingly, the same is rejected. Return back the case. 44. Next.
44 might be by.
44 can be.
My lord, in the FIR, my lord, 3%, my lord, 2% already granted bail. And I have annexed the order passed by lordship. My lord, only for my lord, heavily, my lord, graphs, this FIR has been lost. In fact, my lord, the present informant, against him, there are 3 cases are pending. Your lordship, kindly consider, my lord, since my lord prime accused already been granted bail, my lord.
So this person is was the prime accused.
My lord,
Mia
23, my lord.
Danesh Ali. Danesh Ali.
Yes, my lord. Rupamia and Danesh Ali already granted. My lord, in fact, my lord, the FIR was lost in 18/12/2024. Now, my lord, a new, my lord, IO has come, my lord. Now, my lord, they are searching, my lord. My lord, I will cooperate with the investigation, my lord. My lord, only for if chance may be given, my lord.
Yes.
We have received the CD, my lord. So, my lord, here before coming to the my lord matter, my lord, one, my lord, that is order is annexed, my lord. That is in page 23, my lord.
Okay.
Page 23 of the petition, my lord. Their contention is that these are the two accused persons. One is Tutamia and Danesh Ali. They were granted bail, my lord, by this honorable court, my lord, after perusal of the CD, my lord. So now, what I understand is that their submission is that the parity will come because they are similarly situated, my lord, both parity in fact and parity of law. Now, my lord, here this order was passed on 4/8/2025, my lord.
Okay.
4/8/2025, when my lord was pleased to, my lord, grant the bail, my lord. Now, my lord, what is the new development from 4/8/25 and thereafter, my lord? 4/8/25, my lord, when my lord was pleased to grant this bail, at that point of time, we didn't have the FSL report, my lord. We had only PM report, my lord. Now, my lord, FSL report is available, which was, my lord, that is FSL report was issued on, my lord, 26/8/2025. My lord, may I kindly peruse the CD, my lord?
My lord, in the FIR, my lord, it has been, my lord, alleged that, my lord, the victim, my lord, committed suicide.
Yes, my lord. I'm coming to that part also, because, my lord, that is, my lord, reflected in the, my lord,
There is no
order also, my lord.
Sir, my lord.
In page 24 of the order, my lord, para 5, my lord, where, my lord, it is clearly stated, my lord, that is the learned additional public prosecutor submits that the case diary has been received, has drawn attention to the relevant part of the investigation. Upon perusing the same, I find that the investigation had revealed materials so and so, so and so. So, my lord, at that point of time, my lord, to that extent, my lord, one, my lord, note is there. Again, I have flag marked that note, my lord. But, my lord, after receiving, my lord, that is the FSL report, where, my lord, that is, it is shown that, my lord, that is the, my lord, the kind of, my lord, poison is there, my lord, the which is, my lord, used, my lord. Thereafter, my lord, the investigation going to it another, my lord, direction, my lord. Thereafter, another notes come, my lord. And they now in this instant case, my lord, they file, my lord, that is the objection also. All relevant parts I have flag marked, my lord. I will may kindly peruse the same.
According to you, the parity aspect will not come.
That will not come, my lord. At that point of time, we don't have, my lord, that is the FSL report, my lord. That is, my lord, 26/8. Now, my lord, here, my lord, from the FSL, it is very clear. That is, my lord, organophosphorus, my lord, insecticide, my lord. That is, my lord, in the, my lord, test report, my lord. That was not available at that point of time. Now, my lord, the story in the two side. One is that, my lord, some witnesses, my lord, till then they said that because, my lord, that the FIR is lost, my lord, that there's that is the because of the actions of the deceased sons, my lord, he committed suicide. But, my lord, the other story is that they demanded, my lord, money 2 lakhs, my lord. Some independent witnesses are also there. VDP person is also there, my lord. And because of that pressure, my lord, he has no other way. He, my lord, take the poison. And even, my lord, that is the statements, my lord, before the, my lord, the magistrate, my lord, which is recorded. There, my lord, they stated, my lord, the use of the poison at that point of time. Now, my lord, it is very clear, my lord. That part is there. And, my lord, that is the last
part is that, my lord, that is the wife of the deceased was, my lord, that time, my lord, present. She stated that, my lord, he came from the house of the Totamia, my lord, who was already, my lord, given that is the liberty of the, my lord, the pre-arrest bail, my lord. So from Totamia's house, my lord, when he left, he took some glass of water there and he came, my lord.
My lord, page 18 may be perused, my lord. Page 18, my lord, of my petition, my lord. Initially, my lord, we filed a case against the informant. And in that case, my lord, police create pressurized. My lord, page 18, Annex 2. My lord,
Page 18.
page 18, my lord.
It was registered as
My lord, yes, my lord, it was registered, my lord. My lord, it was,
Bagmani PS 16 of 24.
yes, my lord. My lord, because of this case, and another case is pending against informant. And that's why police frequently visited the house of the informant for his arrest. And subsequently, the informant was, my lord, absconding. Pressurized goes to the father of the informant. My lord, he was very innocent person, my lord. My lord, due to pressurized created by the, my lord, police, he committed suicide, my lord. Now, my lord, regarding, my lord, the allegation of 2 lakhs goes to us. It is absolutely false, my lord.
It has been stated in the magistrate statement also. It is stated before the magistrate. It has also been, anyway, we'll see.
My lord,
Yeah,
my
then
humble submission, my lord, I will appear, my lord, before IO, my lord.
This,
My lord,
page 23, 24, para 2 and 3, para 2 and 3, see. Full stop. Drawing attention to order dated 4/8/2025, passed in AB 1537/25, granting pre-arrest bail to co-accused to Mia and Daneshal. The learned counsel for the present petitioners are also seeking bail on the aspect of parity. The case diary has been reviewed along with a bail objection. The learned additional PT objecting to the grant of bail submits that in the meantime, the FSL report has also come indicating, giving positive test for the poison. Stop. Poison in the nature of organophosphorus insecticide. Stop. In the bail objection, it is stated by the IO that the deceased was mentally harassed by the accused persons with the threat of cases and demand of rupees 2 lakhs. And he eventually consumed poison on 17/12/2025. 17/12/2024.
My lord, this is a 24, my lord. The 24, my lord.
24.
Long time back, huh?
Long time back. It is a long time.
Long time now.
That aspect is there. The harassment of the petitioners, harassment of the deceased / victim also emerges from the materials in the case that statements of 2 witnesses are recorded before learned JMFC. Statements of 3 witnesses recorded before learned JMFC are also available. The witnesses have also stated about the demand of rupees 2 lakhs. Except for the elapse of time, otherwise they are materials.
Yes,
Time aspect is there.
yes, my lord.
Only the time.
Only, my lord, the parity will not come, my lord, because, my lord, from the case of Tarun Kumar and EDs also, that is very clear, my lord. So that part.
The learned additional PP submits that in view of the significant incriminating materials revealed by the investigation subsequently, the aspect of parity may not come. And given my consideration to the materials, and also to the aspect of parity. Considering the materials and the circumstances, I am unable to find sufficient justification for anticipatory bail in the instant case. Accordingly, the bail petition stands rejected at this stage. Return to case diary.
Fifty-nine.
This one. Timing?
City and City.
No. I do that. Ten.
My lord, CD not received, my lord.
This is disposed of. Okay.
City was.
I is disposed of. We will extend it then. It's pending for a long time, long. time.
Yes, my lord, very long time, my lord. My lord, only last sons may be given, my lord.
What is the allegation?
366, my lord. 366A.
Girl has been recovered?
Recovered.
Huh?
Recovered.
Minor girl 16. Any material to indicate from your side? Thank you.
My lord, CD not received, my lord. So
Nothing
we are
to-
not.
Any material in the petition from your materials that the girl has been recovered? Or your statement or something? Because otherwise I can dispose it off also. No, instead of keeping it pending for so long. What do you say, Mr. Boyso?
My lord, last sons
He's
may
on
be given, my
interim,
lord.
actually. He's on interim. Actually, if the girl has been recovered, wait
Last
for
1
the
year, my lord.
remaining investigation or other consequences. But if we are not sure about the recovery of the
Yes,
girl.
my lord, that and my lord, sometimes, my lord, the age is also matters. Sometimes, my lord. So because of that, my lord, I'm paying very short date, my lord, very short date, my lord.
I'm just trying to gather.
Or maybe on 9th, my lord. We'll try to, my lord.
It will be, we are overloaded. Okay. Case diary is not yet received, full stop. Issue reminder for the same. Interim bail dated 26/4/2024. 1.5 years.
Yes,
Bail petition
yes, my
cannot be
lord, my
continued for
lord.
so
It
long.
should not be, it should not be, my lord.
That's why I wanted to dispose it of. If the girls available,
Yes, ma'am.
girls recovery is on record. Let us see. We may have missed something. No, it's not reflexive. Have you stated, do you have any information? Have you stated in your petition about recovery of the girl?
No, my lord.
You have not, no, you have not.
There's the interim order, man.
I feel awkward actually keeping it pending for so long.
My
Isn't
lord,
it?
my lord, then fix it on 9th, my lord. An order, copy of the order, my lord, reflecting all this, that because my lord, this pending from
This,
2024, my
my
lord.
petition has been pending for a long time. Therefore, I deem it necessary to dispose it of. Hence, the CD must be sent positively on the next day. Fix on, interim bail stands extended till the next day, fix on
In
9/1.
There's
We'll take
9/1.
this.
A copy of the order also may be provided, my lord.
Yes.
Copy of this order, my lord.
Copy of this order shall be furnished to the prosecution. In the meantime, you also take instructions.
My lord.
You get
My
some
lord,
material.
my
you know,
lord,
somebody, something about recovery of the girl or whatever.
There is interim order, my lord.
Yes, I'm extending the interim order. You take some instructions
my lord.
60.
about the recovery of the girl.
My lord,
You
my-
can also take,
Yes, my
you can also.
My
take,
lord.
If that much we get, the girl
Yes,
has
my
been
lord. Yes, my
recovered,
lord.
perhaps. Okay. 60.
May it
Yes. Right, sure.
On a pre-arrest bill application, interim was provided. I think my instruction goes, I have appeared. FIR is at page 12. I am not named in the FIR. The person who was named in the FIR, he was arrested. Thereafter, my lord, I have annexed those documents. He was practicing, he was under something and he was, and the petitioner was the registrar of that institution. And my lord, the As regards the
Office of the Registrar.
alternative medicine, page 12, long FIR. Please. FIR against one individual US senior practicing as medical practitioner, and he was under the authority of that Northeast Council of Alternative Medicine, under which, and he was practicing. That was the allegation, and he was arrested. My lord,
He
the
was practicing without having the.
that, but he was under the alternative medicine, and he was practicing. For that, he was arrested. As regards this Assam Council of Medical Registration, my lord, page 23, that was the FIR against that particular person. Then, my lord, he was accused was forwarded. That is at page 32. Now, as regards this alternative medicine, my lord, Northeast Council of Alternative Medicine, page 35. That was the registration issued by the Register of Cooperative Societies, validity up to 14/11/25. Your lordship has got it. And this, under this authority, my lord, this is the Senate of Board of Examination hereby confer Northeast Council of Alternative Medicine, affiliation status and medicine alternatives, and this is the certificates. Then, my lord, Joint Director of Health Service, National Rural Health Commission also issued a certificate. Page 38, another.
But such people cannot write doctor. I think.
Oh, my lord, that was there.
that
Then
can-
ultimately, I am the person who was working as a registrar. I am not a doctor, I am doctorate. Page 45, your lordship will find. I have resigned from that institution in the year 2022.
And at the time of resigning, you were registered.
Register. I have never practiced as that. And I have been on an interim, I have appeared. Now, what has happened, my lord, is in the case diary.
Got it.
Well, it's CD receipt, my lord. As my learned senior has already stated, my lord, that he was the my lord register. Yes, my lord. My lord, here, my lord, his statement is recorded, but my lord, police, my lord, file an detailed objection in this regard. Because, my lord, this is a case, my lord, where, my lord, the civilians, my lord, the public at large are not able to identify who is a doctor, who is not an alternate medicine practitioner, my lord. And this is, my lord, file, my lord. And because of such process, my lord, that is the threat comes to the public at large, my lord. And this is not a one case that, my lord, during the course of investigation, it is found that it is not a one case that one person is given that, my lord. Actually, it is an access, they are providing such kind of certificate, my lord. And, my lord, though his statement
This
is.
institute.
Yes, my lord, this institute, my lord. Now, 2022, I closed the thing and I withdrew the thing. That doesn't mean that, my lord, offense was not committed at that point of time. And, my lord, the persons, those who have come out from that institution, that's also, those are should also be come to the, my lord, the scanner, my lord. So, my lord, my humble prayer before your lordship is that at this stage, my lord, it is very in the nascent stage, my lord, till, my lord, though, my lord, his statements are, my lord, recorded, that is not enough, my lord. And even in this case, my lord, very much custodial interrogation is required. My lord, find out the loop, my lord.
Yeah, no.
Relevant parts, my lord, I have flag mark. My lord, may kindly peruse the same.
I have given my statement, my lord, I will cooperate. What more behind the bar, what more they can acquire from me? I am not fleeing away. I am giving my statement, I will place everything. I am a qualified PhD person. I was an employee of the institution.
The institute is not fake, right? That is not.
The
fake.
institute is not fake.
My lord, these things are not actually available. My lord, in the, my lord, FIR, because the FIR is lodged by one, my lord, there is an authority, my lord. There is a, my lord.
No, somebody issuing fake certificates in.
My lord, these are not,
on
my
behalf of
lord,
a genuine institute. That is one.
my lord, it
that
is
is
not,
one
my
aspect.
lord, those parts are not there, my lord.
No.
Even, my lord, the notes are there, my lord. They are not able to give any, my lord, that is the, my lord, documents and nothing. Only that is the annexure, which is, my lord, just provided there, only they have, my lord, provided. So, my lord, in this case, my lord, there is the investigation
statement
is
is there?
needed, my lord. His
His
statement, yes, my lord. I have flag mark all relevant parts, my lord.
Institution is not a fake one.
No.
Institution is a valid one. I was an employee, I was working as a registrar.
Some people have issued fake certificates for.
And my lord, I appeared and before the investigation order, I gave my statement, whatever. If a genuine institution, I am been allowed to work over there. As a qualified person, I am a MSc, PhD and other qualifications, your lordship will find at page 45. And neither I am a doctor that I am practicing illegally. And this certificate that I have annexed, even my lord, your lordship may look into this certificate. which was issued by, at page 40, your lordship will find about the institution.
Yes. Page 40.
Page 40 of the petition, your lordship will find about the institution.
Yes, I've seen this.
And all earlier, the joint director of health and everybody has given the certificates. And I was working over there as a registrar. Had the institution be a fake one, then it would have been different. Then I cannot join anywhere.
I've seen anyway.
And the accused was arrested, man.
Mhm.
Only thing that the allegation is that a person cannot use the word doctor
Yes.
and cannot practice in some this regular medicine pharmacy.
The bail objection is mostly against this person, US Sinha,
US
who was using the doctor.
Yes, my lord.
prefix. That is not permissible. Doctor, you cannot do
That's not permissible, my lord. Now,
I was not named in the affair also.
If you look. Invite order dated 29/10/2025. The petitioner herein was granted interim bail pursuant to which he appeared before the IO. And his statement has been recorded. Full stop. The updated case diary has been, the case diary has been, as called for, has been received. Full stop. The case arose out of an FIR lodged by Assam Council of Medical Registration before the OC of Sonai PS on 15/9/2025. One of the main allegations is that one person by the name US Sinha is practicing as a medical practitioner at Manas Medical Hall, situated at a place in the district of Kasar, projecting himself to be a doctor, though he's not a qualified doctor. Stop. It is alleged that such acts are endangering public safety and also violates the provisions of the National Medical Commission Act 2019. Good stop. The present petitioner is stated to be not named in the FIR and he's stated to be a PhD holder, and before resigning from the job in 2023, right?
22, my lord.
22, he was working as Register of the Northeast Council of Alternative Medicine. Good stuff. In the FIR, it has been alleged that this Northeast Council of Alternative Medicine is a fake institute.
Yes, my lord.
Fake institute.
Yes, my lord. And it is, my lord, it is filed by authority, my lord. That is, my lord, Assam Council of Medical
That is an
Registration.
important consideration. If the
Yes, my lord.
because he's a qualified person, and
Well,
he's
yes,
a
if the
registrar of a
qualified
fake
person, then
organization.
he
As
should
per
be
your
more
instruction,
careful,
it's
my lord.
fake.
Not
As
fake,
per your
because this
instruction, it's
certificate,
fake.
my lord, how the certificates of joint health, my lord, their documents, I'm issuing this certificate, my lord, my lord, Joint Director of Health Service, District Program Manager, District Media Expert, then, my lord, at page 39 and page 40, I will not say the name, my lord. Page 40, your lordship has got that certificate, message. At page 39, your lordship has found, in 13, it was also given, Joint Director of Health Service.
The Learned Petitioner Council has drawn attention to several documents purportedly issued from the health authorities of the government of Assam, including NRHM regarding the Northeast Council of Alternative Medicine. Not a fake organization as alleged in the FIR. Unlike the main accused US Sena, there is no allegation against the present petitioner about misrepresenting his educational credentials. Nevertheless, despite the objection of the prosecution side regarding grant of bail in the instant case, I'm of the considered view that since the investigation has progressed to some extent, at least, and the petitioner has also appeared before the pursuant to grant of interim and his statement recorded, perhaps it may not be necessary to cancel his interim and cancel his interim footstep. Accordingly, in such view of the matter, the interim bail granted by order dated 29/10 is hereby made absolute, subject to the condition that he shall render cooperation to the remaining investigation and not hamper or tamper with evidence, cannot indulge in any illegal activities or offences. Return case there.
Obliged, ma'am.
Settlement or something, that should have been very short.
May it please your lordships. Lordships that fixed this matter at 2 p.m. today due to the urgency reflected in the petition. It is a maintenance matter. The petitioner is.
Your appearing
Legal aid
as
counsel.
legal aid counsel. Yes,
Yes,
I remember.
So in this particular matter, the petitioner was married to the respondent, and out of their wedlock, they have 2 children. The first child was born on 17/1/2011, and the second child was born on 20th of June 2014. Since 1st November 2020, the petitioner has been living with her at her parental house. And subsequent to that, in the year 2022, the petitioner had filed a complaint under section 125 of CRPC
Yes.
before the Chief Judicial Magistrate Bongaigaon. In this petition, she had claimed maintenance for herself as well as her two minor daughters.
Okay.
She had
Maintenance was granted?
Lordship, maintenance was granted only with regard to the two minor daughters, and that too the amount was only 3,000 rupees per month. Whereas the salary which the respondent himself has admitted in his evidence in chief is rupees 48,555. In the cross also, he has not denied this. It is in his own affidavit, 48,555.
The income affidavits.
Income.
Income.
He's a railway servant, railway employee. So his income is 48,555. But Lordship, the most important.
And no compensation, no maintenance was given.
No
with regard
maintenance
to
granted to the petitioner.
petition. She is agreed by that also.
Yes, Lordship.
She wants,
The-
she wants maintenance for herself
for
and
herself as
enhancement
well
for the
as
children.
enhancement for the children. But Lordship, the major hurdle that will come before this honorable court in this particular matter is that the judgment passed by the Honorable Supreme Court in Rajneesh versus Neha
Yes.
has not been complied with by the learned trial court nor by the revisional court.
Is it? No income, that's why I was asking. No income affidavits were called.
No, Lordship. No income affidavits were called for.
It's like it may not be fatal, maybe.
Lordship,
subject to
this-
correction, provided because see, the whole purpose of that exercise is to, help the courts come to a correct determination.
Yes, Lordship.
If
But
correct determination has been made if there are materials to help in such correct determination,
the
then it may not be fatal.
the only thing that is available before us is the respondent's admission that his income was 48,555. But in my humble understanding, the other liabilities which the respondent has, that is not before this honorable court. And the respondent has neither appeared before this honorable court in spite of notice having been duly delivered. So in such
He's
circumstances,
working in which division of railway?
Lordship,
Notice could have been, I
we
don't
don't know
want
the
to delay the
pres-
matter, but the thing is that notice could have been sent to the railway authorities if he's working, then it would be served upon him.
But
It
the
could have been
address
sent
which-
through the, we could have directed notice through the railway authority. Suppose he's working in Lamding or something, then it would be served. Suppose he's a railway employee.
we don't know right now where is he posted.
Received by the brother in the same house.
Yes,
So
Lordship.
it is,
And that was the address which was given by the respondent as well.
okay.
That
So-
address was given
so,
by the evidence in chief.
These days, what would be your prayer to go into the matter?
Lordship, my humble prayer before this honorable court would be that the matter may be remanded back to the trial court, directing the trial court to take into consideration and comply with the directions given by the Honorable Supreme Court in Rajneesh versus Neha. Call for the affidavits of assets and liabilities, and thereafter determine as to
That we
how
can
much
always do.
maintenance.
That we can always do.
Yes,
That
Lordship.
will not prejudice him in any manner.
Had the respondent been here, Lordship, then this honorable court would have been in a position to call for the affidavits from both the parties. But since the respondent is not here, it would cause prejudice.
Let's do that only.
Okay.
Dispose of those stuff. Third, we can have a seat. Yeah, we can have a seat. If I need, I'll call you again. Third, Pooja Agarwal, learned counsel appearing for the petitioner. Their marriage is subsisting, right, as per your instruction?
Yes, Lordship. Marriage is subsisting.
For the petitioner, Pinky Bora, as a legal aid counsel. None appears on behalf of the respondent, Torun Bora, stated to be the husband. As per order dated 17/12/2025, the notice sent to the stated address was received by his brother, and service upon respond number 2 was held to be complete. Full stop. Some scan copy has been received, that's. Scan copy has not been received, so I think we can dispose it of
Yes, Lordship.
without that also.
Yes, Lordship.
Scan copy of the TCR pertaining to miss case number 3 of 22 was called for from the learned JMSC Bongaigaon, but it has not yet been received. The facts in brief is that the petitioner as first party, petitioner Pinky Burwa as first party had preferred a petition seeking maintenance for herself and her two minor daughters, invoking the provisions of section 125 CRPC within bracket as it existed then. The respondent's husband appeared as second party. Respondent husband / second party appeared after notice, and the learned court below was pleased to grant. Just help me with some of the facts. Huh? Rajneesh versus Neha judgment is of the which year? I forgot.
Lordship, the citation is that this.
21.
Lordship, the judgment was passed on 4/11/2020, but the
20
citation is
Yeah, during the
2021.
COVID time, that's not there, not that time. By order dated 21/9/2023 by the learned GMFC Bongaigaon, whereby the learned magistrate was pleased to grant a monthly maintenance of rupees 3,000 each to the two minor daughters of the petitioner. However, no maintenance was granted to the petitioner for herself. It is reflected in the said order of the learned JMFC in para 24, and that the respondent husband has admitted in cross-examination that he is receiving rupees 48,555 as salary. Full stop. It is submitted. Ms. P. Agarwal, learned legal aid counsel, submits that the respondent is a railway employee, and in view of his admitted salary, the compensation, the maintenance awarded to the daughters is very much on the lower side, and that the petitioner should also have been granted maintenance as he is unable to maintain herself. The said order of the learned JMFC was taken up in revision before the learned session judge Bongaigaon, giving rise to criminal revision 21 of 2023, which was disposed of on 22/5/2024, upholding that order, right? Upholding the order of the learned.
Yes, Lordship.
No change. Right?
No change.
Leaving the order of the learned JMFC undisturbed. Stop. In such backdrop, petitioner is before this court. In the course of argument, learned counsel for the petitioner, Ms. Agarwal, submits that at the time of adjudication of the claims for maintenance, no affidavit of assets, liabilities, and income in terms of the judgment of the Honorable Supreme Court in the case of Rajneesh versus Neha, 2021.
House 21.
Yes, 2021.
Volume 2 SCC, page 324.
Volume 2 SCC, page 324, was before the learned court below. And also, not before and also the revisional court. Therefore, one of the essential, one of the essential procedural requirements. One of the essential materials was not before the courts below in passing the order of maintenance. Though the admitted position regarding the salary of the respondent was available. It is submitted by the learned counsel that in these circumstances, perhaps the court can consider remanding back the matter for a fresh determination after calling for the income affidavits of both the sets. Needless to say that the requirement of submitting income affidavits of income, asset liability and income in the judgment of Rajneesh versus Rajneesh within brackets Supra is to impart greater objectivity to the adjudication and determination of maintenance and arrive at a figure considering the needs of the petitioner and the paying capacity of the needs of the first party and paying capacity of the second party. Good stuff. As the respondent side is also unavailable in the present adjudication before this court, I find force in the limited prayer of the petitioner counsel. And perhaps such a course of action might assist in the process of arriving at a more effective adjudication, though it will involve some more elapse of time. Accordingly, the facts and circumstances and in the backdrop of the above discussion, the impugned judgment and order dated so and so, hereby set aside. And the matter is remanded back to the court of the learned CJM. I said it to CJM, JMFC. CJM will give it to another.
The order was passed by
JMFC. JMFC Bongaigaon,
Lodge.
right?
It was passed by GMFC Bongaigaon.
Yes. The same court?
Lordship, the
Remanded?
same court.
Same to the, because
GMFC Bongaigaon.
the court of the learned JMFC Bongaigaon for a fresh determination of the claim for maintenance of the petitioner for herself and her two daughters after calling for income affidavit of asset liabilities and income from both the sides in terms of the law laid down in Rajneesh versus Nehru. Stop. Again, you have to adduce evidence.
Lordship, the revisional court order may also be set aside.
Yes, yes, both just merged actually, but both.
Lordship, if a time frame could be given, because they have been suffering since 2020.
Yes,
The
that's it.
petitioner does not have any source of
Again,
income.
how many witnesses were examined at that time?
Lordship, from the petitioner side, there were just two witnesses, petitioner herself and the petitioner's mother. And from the respondent
be-
side, it was the respondent
Do
himself.
they have to be examined again?
No, Lordship, that will not be required. It's only the affidavit that is required, and on the basis of that, the court can take a decision. Because the evidence will not be changing. The evidence will remain the same.
The evidence of the parties adduced during the earlier round of litigation would still be on record. And learned JMFC, learned court below, JMFC Bongaigaon, after the remand shall merely call for the income affidavits of both the sides and make a fresh determination taking into account the additional material in the form of the affidavits of income liabilities and assets. Assets, liabilities and income. Because otherwise they will get confused, right?
Yes,
Just
Lordship.
to be clear. You want a time frame?
Yes, Lordship, that would be better because it's been more than 5 years.
It is submitted by the learned counsel that as the petitioner and her daughters have been seeking maintenance, have been seeking maintenance for considerable period spanning several years. Therefore, perhaps it would be better to stipulate a time frame for the aforesaid exercise. I've given my consideration to the matter. So, the learned court below shall endeavor, it will be better to write like that only, they will try. Shall endeavor to conduct the aforesaid exercise of income affidavits and passing a fresh order within a period of how many months? 3 months?
Yes, Lordship, 3 months from the date of first appearance. A date of first appearance may be fixed by this honorable court.
From the date of appearance of the parties, appearance of the petitioner, appearance of the parties before the learned court below for this purpose. But they will not know. No?
Lordship, so far as the petitioner is concerned, she can appear and apprise the learned trial court with regard to this honorable court's order, and thereafter notice may be issued to the respondent.
Yes. The petitioner shall appear before the learned GMFC Bongaigaon on, you can choose a date.
Lordship, as your Lordship suggests, there is no problem.
Last week of January, will it be okay?
Lordship.
On 28 or 28 or 29, 28/1/2025, 26.
Deeply obliged.
Instead, the instant criminal petition stands disposed of on the aforesaid terms. After, while correcting, I'll fine tune it.
Lordship.
Necessary.
Deeply obliged.
The court appreciates the effort of the learned legal aid counsel, which will be entitled to the usual fees.
Obliged.
What I did, I don't know who was the settlement from. I think this is the just even it was 60.
It is of 57.
May it please your Lordship. My lord. This
You're here?
particular criminal proceeding for quashing, my lord.
You're appearing for the
Respondent number 2 on behalf of
Yesterday we
S. Ahmed.
confirmed affidavit, no problem.
I have no objection.
You have settled it. Yes.
My lord, in the meantime, this joint affidavit has been filed. So I pray that, my lord, this particular FIR and the proceeding thereof may be quashed. GR proceedings, my lord. In that joint affidavit, my lord, paragraph 7.
Just a minute, huh?
Yes.
Okay, para.
Joint affidavit, paragraph 7, my lord.
Yeah.
That as the matter is disputing is private in nature and will not affect public at large, and both the parties to the dispute have amicably settled the matter out of the court and nobody is aggrieved. And therefore the deponents pray that the honorable court to set aside and quash the GR case number which is pending in the court of learned judicial magistrate first class, Kamru Petro. Uncompromised. And the sections involve my lord 323, 294 and 423. 427, all are petty in nature, my lord. And
354 also.
323, 294 and 427 of the IPC.
354 is not there.
No. 294 was there, my lord.
294. Wrongly written, I think.
Probably. 294.
the CR case will be withdrawn.
CR case should be withdrawn, my lord. That may be, my lord, quashed, my lord, set aside, entire proceeding, my lord.
No, no,
GR.
GR will be quashed.
Yes, GR will be
GR.
quashed.
Okay, no problem.
And the CR case, my lord, will withdraw, no?
Yeah, that's what I've written.
In the
That's
trial
what
court.
I've written. We'll reflect that paragraph in the.
Yes,
order.
yes. In the joint petition, my lord, I have also annexed the MOU, my lord, in between the parties.
Yes, yes. Para 7(2).
Section के पे बस ना.
Because it's 350, you have also written, 354 you have written.
My lord, but,
354. But
in the FIR, it was registered under those
elements
sections.
of 354 may not come.
But my lord, at page 30, my lord will find, finding sufficient materials on record, it is presumed that the accused has committed offence punishable under section 323, 294 and 427 IPC. Cognizance were taken under these provisions, my lord. Although FIR,
Right.
yes, FIR is registered under other sections, my lord.
No, even if 354 is given, the
Yeah.
rightly taken, because prima facie, though this or 354 may not come, it's
Yeah.
also. Any civil petition to hurt each other, learned counsel for the. And, also your name will also be given. Your name, yesterday you did not?
Yes.
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 And your good name?
Iftiuddin.
For the respond number 2 plus informant. And FIR was lodged, FIR dated so was lodged before the All Women Police Station, Guwahati, with the allegations. And that while the informant was constructing, doing some construction over her land, the petitioner herein was her neighbor, was disturbing and threatening her workers. And on 14/5/2013, in the morning, he broke the windows of her house, entered her home and assaulted her son. It is alleged that he also assaulted her by hand and abused her and her daughter-in-law with slang language. On the basis of the FIR, All Women case number 99/13 was registered under so-and-so section, page 81. The corresponding GR case was GR number 5888/13. Mr. Hazarika, learned counsel submits that, however, cognizance was taken by the court under section 323.
323,
294,
294 and 427 IPC.
427 IPC.
And charges were explained, my lord, under this.
Offense explanation.
Yes, offense explained.
An offense was explained. In the meantime, the petitioner and the informant arrived at a settlement. Settlement was entered into by the informant's son.
Informant also, yes, informant's son and the informant. And she was also made a party, my lord. She was also signatory to the MOU.
Respond number 2 is the Son,
Respondent two is the son.
son, not the informant.
No, no, here, my lord, in the instant, FIR, it is the mother.
Mhm.
Page 15, my lord.
Then Nanu, no, this person, Iftikhar Hussain,
yeah.
Nanu. Nanu's mother is respondent number 2,
Respondent two, Rehana Hussain.
Rehana Hussain. And the agreement, no, I will do it, but they're just getting my facts right.
Yes, yes, my
The
lord.
agreement was made between Nanu and the petitioner.
Yes, Saju and Nanu, my lord, they are first cousins. So, and on the next page, my lord, Rehana Hussain also is
Signed.
there.
In the meantime, an agreement was entered into between the petitioner, Parvez Hussain alias Saju, and Iftikhar Hussain alias Nanu, stated to be the son of the informant and also one of the alleged victims. A copy of the same has been annexed with the petition. As for the state settlement, both the parties have undertaken to amicably compromise the matter, whereby the CR case number 706/16
Yes,
pending before learned GMFC Guwahati would be withdrawn,
yes, my lord.
and it has been prayed in this petition, and the first party, and that the petitioner and the informant shall file a joint petition, file a joint affidavit in criminal petition, in the present criminal petition, for quashing the GR case 5888 of 2013, right? 1107. Now, we'll stop. My attention has been drawn that the said Rehana
Yes,
Hussain,
yes, she is also there in the MOU, my lord.
she has also, Rehana Hussain has also signed on the state agreement,
Yes,
and she has been impleaded here, yes? Not impleaded.
yes, my lord, she is the respondent two.
Yes. And she is respondent number 2 in this petition. Learned counsel entering appearance on behalf of respondent number 2. Your name to लिखी है already. Supports the settlement and submits that the informant has given her consent to such amicable settlement between the parties, and has no objection to the prayer of the petitioner for quashing of the criminal proceeding. It is also pointed out by both the learned counsels that the petitioner and the said so and so, Iftikhar Hussain alias son Nanu, stated to be the son of the informant, are cousin brothers.
Cousin brothers, first cousin.
I have given my consideration to the matter, and in my considered view, it will be justified and fair to allow the prayer for quashing. Accordingly, the entire proceeding of GR case number so and so shall stand quashed.
Yes.
Okay? The rest you do before.
Yes, we'll do that, my lord.
Instant criminal petition stands allowed and disposed of by force of terms.
I am deeply obliged, my lord.
I should have written it shorter.
Yes.
Got a little longer, but well,
Anyway,
today slightly unwell.
Deeply obliged.
Obliged. Will do. So,
May I please allot, Lordship, I is for suspension of sentence and for release of applicants on bail, Lordship. Trial court records are there, Lordship. Lordship may kindly come to the FIR, Lordship. The applicants were convicted under 411 and 34 IPC, Lordship, and sentenced to undergo rigorous imprisonment for 3 years, Lordship. FIR, Lordship.
Let's see one thing, just a minute.
Trial court record is there, Lordship.
So,
biography. Years. Section 411. I hold 411 to IPC.
actually, he is in custody now.
Custody law.
Actually, that's what I was cross-checking. Anyway,
Lordship, during
time-
investigation, 35 days, and thereafter from the date of sentence, from 1610, he is inside. 118 days, Lordship, as on today.
Because, okay. fine.
Appeal has been admitted, Lordship may grant.
No, because why I'm asking is because,
Yes, sir.
you see earlier provision only, let us see for the moment. For ease
Yes.
of, what is the, I don't know, what is the corresponding section of the 389, subsection 3,
3.
clause 1. That up to 3 years, that convicting court itself can grant bail, actually. They could have, actually. Anyway,
But that was rejected, Lordship. Lordship may
but that
kindly
was
come.
rejected.
Yes, rejected.
Yeah, that is not compulsory. This,
Yes.
where the
Lordship may
convicted
kindly come to
satisfies
the-
the court.
Yes,
that
Lordship
he
may kindly
intends
come
to
to page
present
number
an appeal, the court
30,
shall-
Lordship. IA.
shall sentence to- The language is actually of a mandatory.
But that
nature.
was rejected, Lordship. Page number 30 of the IA, Lordship.
All I have to do, that is why we have to see the barracks again and again,
Yes.
no end to it. I have to convince the court, convicting court, that I intend to present an appeal. See that provision, I have to convince only that, not on the merits.
No,
That
not on
I
merits, but-
want to present an appeal.
Yes, yes.
And
that was-
thereafter, the language says the court shall,
That
on
was,
bail,
that was rejected,
is
Lordship.
sentenced to imprisonment for a term not exceeding 3 years.
Lordship may kindly come to page number 30.
Unless there are special reasons for refusing bail.
Up to 3 years, my lord, the
Yeah.
trial court
It's
can.
almost automatic,
Yeah.
unless there are special reasons. So there has to be special reasons.
That was rejected.
Then
Lordship.
only. Usually it is always done. That's why I was saying.
Page 30 of the IA, Lordship.
There might have been some reasons.
Last paragraph, Lordship. Page 30.
Yes.
On perusal of the judgment dated such and such, it transpires that the offences are of defined and continuing in nature. The convicts were sentenced to suffer 3 years rigorous imprisonment for the offence under 411-34 IPC, and thus considering the nature and gravity of the offence, this court is reluctant to grant bail to the convicts. At this stage, I can really, the instant petition stand rejected.
Beg to disagree. Anyway, it's okay. It can always be here and there. Appeal has been admitted.
Admitted, Lordship. For consideration of this IA, Lordship, trial court record was called for, Lordship. Otherwise, evidence are contradictory, Lordship.
This original record has come, no? Most probably.
Yes.
So- Informant is a police officer. so
Yes.
You
No
can
comment.
represent
Yes,
him.
my lord.
You can represent him. First, we'll write on the criminal appeal to take it over. While order dated 1/12/2025. The appeal has already been admitted. And informant, being a police officer, is being represented by the prosecution. First up, the case record of Sessions case number
62/23.
62 of 23 have been received from the learned trial court. That is Session Judge Udalguri. This can be posted for hearing.
Yes,
right?
sir, appeal may be admitted, my lord. and-
Appeal
It's
has already
admitted.
been admitted, Lordship.
Already
It may be released on bail, Lordship.
I'll
Yes,
come
my
to
lord,
that.
That order may be passed.
I'll come to that. No, this order, it may be listed in the usual course.
Yes, usual course.
Usual course is very dangerous.
2025 matter, my lord, otherwise.
Anyway, the appeal may be listed in the usual course. Listed for hearing, final hearing, the usual course, on a date to be fixed by the registry. (4:30) BNSS. Yeah, your good name, please.
P. Bujumdar.
P. Mozumdar. Record and RJ Bolo. Okay, আপনি last order to the first paragraph to the second paragraph to go. Okay. The informant is being represented by the learned prosecution, represented by learned additional PP, RJ Mr. Bora. Full stop. By the aforesaid impugned judgment and order, the applicant appellant for his conviction under, how many applicants are there here? Two, the applicants for their conviction under 411(3)34 have been sentenced to undergo
Rigorous imprisonment of 3 years.
rigorous imprisonment for 2 years each. No fine, right?
No fine.
No fine. Good stop. It is submitted that after the conviction and sentence, though they wait for bail in terms of section 530. This was at the time it was PRPC? Hmm? No, it is, no. No.
The date of sentencing is 16/10/2025.
16/10.
At that time, BNS.
530 BNSS, the same was rejected. And presently they are in custody. It's step. The provisions of section 530 BNSS. What is the corresponding section of 389?
318.
Don't be.
520.
430. 430. 430. উঠাই দিব relevant 430 sub close to তাহলে হবে I'm just trying 430 this one 430 sub close 3
439.
430 sub close 3 reproduce your
28.
430 over 430.
considering the nature of the sentence and the fact that there may not be immediate possibility of disposal of the criminal appeal, I deem it fit to suspend the sentence and grant bail to the applicants. In such view of the matter, the execution of the order of sentence dated 16/10/2025 passed by learned Session Judge Dalguri in Sessions case number so and so shall stand suspended till the disposal of the criminal appeal. And full stop. Further, the applicant appellants are hereby allowed to go on bail of rupees. How much? 50,000? 50,000 each with a surety of like amount each to the satisfaction of the learned trial court and subject to the conditions that they shall not abscond. Number 2, they shall be available to receive the appellate judgment. They shall not cause any harm to the informant or other witnesses might have deposed. Cause any harm to the witnesses, police officer, witnesses who might have deposed during the trial. Violation of the bail conditions might entail cancellation of the bail. The interlocutory application stands allowed and disposed of on the aforesaid terms. Interest to date registry the verdict. Right?
Much older.
Bail हो गए प्रोडक्शन लिस्ट के पास है
May I please your lordship? We have challenged the maintenance order passed by the landed magistrate, landed family court Borpeta. It is an application of 438, dated 442. But the only question to be decided here, whether the wife, who is the wife of one person, can swear an affidavit that I have divorced my husband and I got married. Muslim law, that is Shariat Act, does not permit it. Here in this case, your lordship will find that she has filed the maintenance case against this petitioner, who happens to be computer working as a computer operator at Borpeta, and the lady is also working as a computer operator, as well as the respondent is also working as a Mohori of the court matter. Then, but in this case, I take your lordship her evidence, my lord. Kindly peruse her evidence, PW1. It is in the record has come, my lord. PW1. I was married to Manikali in the year 2000.
Just a minute. Let me get acclimatized with this.
I was married to Manikali in 2000. I have 3 children from Manikali, namely Manima Ahmed, present 21 years age. Your lordship got it, just PW1.
I'll come to it. I was married to Manikali. This
Manikali in
the year
2000.
2000. Cross examination.
It is an earlier husband, my lord, first husband. Without divorce, my lord, she claimed that she has married me.
I was married.
I have 3 children from Manikali, namely Manima Ahmed, presently 21 years, Abu Duat Ibrahim, presently 19 years, and Minuja Ahmed, presently 16 years. That Manikali did not divorce me. Interesting. In fact, I gave divorce to Manikali in the year 2017.
Well, actually,
that is a vital point to be decided, which the learned family court judge has not considered at all. I have filed the photocopy of the divorce affidavit, in this case, the original with me. My lord, my only question to your lordship, my lord, for submission, whether by executing an affidavit, one can claim that I am a divorcee without going to the procedure of the Shariat Act.
affidavit is not evidence.
No, not.
But she is appearing. But you know,
And I'll come, my lord.
Islamic law has its own complexity. It is not so easy. But whatever little I know, there's the Dissolution of Muslim Marriage Act 1939.
Yes.
Under that act, suits are filed, right? Before Muslims.
Yes.
Only women can file.
Only women
Very
can file
interesting.
suit.
Only women can file suit. But as you said, that I am not sure. Talaq.
Yes,
only,
yes.
Husband can give.
Husband. Talaq is husband.
Lordship,
I will come to you.
yes.
So,
So, my lord,
she has meant that, I don't know. But anyway, so let us see the impugn order first.
my lord, impugn order is at page 17 onward.
Last part only. What is the relief and
30.
your
Page 30.
second party shall pay order, second maintenance to the first part. Maintenance, that's what I wanted. Maintenance was given only to the wife.
Wife.
The so-called wife.
Yes.
At the rate of 3,000.
3,000.
Nothing to the children or something else.
No, they're all major. My lord, interestingly, the lady is living with this all adult sons. They're living now. She's working in the court, and she has filed this case.
So anyway, so maintenance of 3,000 per month was given to her. The first
Well,
month,
the
third
so-called
month,
wife.
and the husband is contesting not on this aspect of the quantum, but on the aspect of this.
Yes.
The marital status.
Yes, madam.
Marital status.
Marital.
That is what that is the basic contention.
Yes, that is the basic issue.
I'll come to you first. Okay. Now I'll be in a better position to appreciate your submissions. Yes, sir, please.
May I read, my lord? then?
Yes, yes, you can.
Page 13.
Yeah.
In her petition under 125, first party stated that interior that on 3/1/2019 she was socially married on second party in accordance with Mohammedan law through Kabin registered. After marriage for some days, she was residing at her mother's house, and second party also stayed with her at the mother's house for several days, and both cohabited with each other. On 16/5/20, in the evening,
I lost track. Where are you reading from?
page 13 minute,
Of the?
page 13 of the judgment.
What's the judgment?
Revision, that is our.
I went to the depositions. Okay, case 13 of the judgment. Okay, prohibited on
Yes.
16/5.
Yes.
Now I'm with you.
16/5. In the evening, and second party came to our house as first party's mother, and on the same night, he returned to his house. On the following day, the first party went to the house of the second party with her ornaments, etc., and started residing with him at his house. After she maintained conjugal life with him for some days, on 3/6/2020, the second party, along with his parents, brother, and his second wife, demanded 2 lakhs as dowry from her, and as she refused to give the said demanded amount, he severely assaulted her. His family members started torturing her in various manners, like giving trouble in eating and in providing clothes, etc., abusing her in filthy language, not allowing her to touch their household articles, and not providing medicines at the time of illness. They misbehaved with her family members. If any of them visited the house, in spite of all these tortures, first party was continuing to reside in the house of the second party and maintaining the conjugal life with him. On 10/6/20, the second party, along with his family member, again demanded 2 lakhs from her first party and severely assaulted her. And after snatching her season articles, they expelled her from their house. Finding no alternative, she took shelter at her mother's house. On 5/9/20, intending to resume the conjugal life, second party, she went to his house, but as soon as she reached to the courtyard of the house, second party and his wife, Abida Khatun, manhandled and molested her by pulling her clothes, and thereafter the second party, along with his family member, severely assaulted her and drove her out from his house. Finding no alternative, she lodged the case at the police station and thereafter took refuge at her mother's house. Since then, a second party has never come to take her and not provided any maintenance to her. She does not have any income of her own. On the other hand, second party has 9 to 10 bighas of agricultural land, 3 number of pakka houses, 2 number of tin roof houses, 2 number of big fisheries. That apart, he has one computer shop. From all sources, he earns about rupees 1,50,000 per month. He has a sufficient means to provide maintenance to the first party, which he has been willfully neglecting to do so. Hence, the first party has prayed to grant maintenance 15,000 per month for her from the second party. In his written statement, second party has stated interior that first party is not his wife. He never married her. She is already a married woman, having before. Earlier, she had married twice as well. Once she was married to one Manik Ahmed of Manikpur Kabadi, and from his side, she had given 3 children birth, whose names of such and such, and her elder daughter is already has 2 grandchildren, aged 9 years and 6 years, namely Mehdi and Masood. The first party is an aged lady. On the other hand, second party is a youth. The first party, claiming herself as Mohori, used to roam here and there in the court premises of Barpeta, doing miscellaneous works. The second party is an educated BA passed, unemployed boy. Finding no employment, he has started DTP work in Barpeta court premises under one computer owner named Rafiq Ali for about 3 to 4 years. From that income, he has to maintain his old parents. During that period, first party sometimes used to bring documents, affidavits, etc. to second party for doing DTP work. she gradually got closer to him, showing love to him, treating him as her younger brother, and grew his trust on her. Sometimes she also called him for having tea and addressing him as her younger brother. He accordingly respected her as his elder sister. Suddenly on 26/19, the first party informed him that she had fallen seriously ill and that she would not be able to come to Borbeta, and she asked him to come to her house at about 7 a.m. by saying to him that he needed to do DTP work in respect of some urgent documents of affidavits. Initially, second party expressed the unwillingness to go to her house, but on her repeated request, he went to her house at about 9 a.m. to bring the document in respect of which the DTP work was supposed to be done. After he reached to the house, the first party asked him to sit and then started to talk to somebody over phone. Thereafter, as per prior plan, she closed the door of her house and forcibly embraced the second party and started shouting by alleging that he has trying to do illicit work with her. Thereafter, 4 or 5 persons came there and she told them that second party was trying to commit sexual act with her. Then those persons threatened second party of killing him. After that, the first party called her relatives and by showing fear to the second party, took his signature on some blank paper. For the sake of his prestige, second party did not reveal the said incident to anybody. After receiving the notice of his case, he apprehends that the first party might have prepared false marriage certificate with his aforesaid signed blank paper. He also has suspicion against the first party as one day she had taken a selfie from behind by showing love to him as a younger brother. He never contemplated that she would do such an incident in him. Neither he has married her at any point of time, nor has he never cohabited with her. She has brought false allegation against him that he married her. The second party is a poor fellow having no land property of his own. Because of his illegal acts of the first party, he has been compelled to leave the DTP work which he had been doing under the computer owner. He does not have any income of his own. He never married the first party and has no capacity of giving maintenance to her. He has his wife and child and his old parents, hence prayer is maybe dismissed for the case counseling. The case was referred to the learned counselor for the counseling of the parties, but as efforts of conciliation settlement remain unsuccessful, the case proceeded before the court in accordance with law. The point which were required to be determined for arriving at a just decision in this case are as follows. Whether the first party is the wife of the second party, whether the first party is unable to maintain herself, whether the second party has sufficient means to maintain her first party, whether the second party has neglected, refused to maintain the first party, whether the first party is entitled to receive money, maintenance allowances for herself from the second party, and if so, to what quantum. To prove the case, first party examined herself in this case as PW1. She also examined one witness named Sadek Ali as PW2. On the other hand, second party examined himself in this case as DW1. First party stated in her evidence that she married second party in the year 2019 as per the Shariat by executing a Kabinama. PW2 has stated in his evidence that once the second party has asked him to arrange a Kaji because he wanted to marry first party. Accordingly, he arranged a Kaji and a marriage was solemnized at the residence of the first party and he had signed the Kabinama. On the other hand, in his evidence, second party has denied marrying the first party, claiming she was previously married twice and has 3 children from the earlier marriage. He claims himself as an educated but unemployed individual who worked as a DTP operator at Borbeta Court, where he came to contact with the first party who treated him like a younger brother. He contends that on 26/2019, she called him to her house under the pretext of urgent DTP work, but upon his arrival, she locked the door, forcibly embraced him, and falsely accused him of misconduct. Soon after, several people entered, threatened him, and forced him to sign blank papers, which he now fears to maybe have been used as a fabricated a false marriage certificate. He also claims she once took a selfie with him and behind, pretending to show affection as an elder sister. Asserting that he never married or cohabited with her, second party maintains that all allegations are false. Discharging her initial burden to proof regarding the claim of marriage, first party has examined PW2 in his case, who testified that he had seen the second party coming to her residence and that at the instance of second party, he arranged a kaji after which the marriage was solemnized at the residence of the first party and he signed in the Kabinnama. Furthermore, first party has filed certain documents, this case, including the Kabinnama and the marriage certificate. Both the documents show the registration number of such and such, such and such. Name of PWD appears in the Kabinnama as bride's ukil. On the other hand, second party on whom the onus to disprove the factum of the marriage has not been able to discharge the said onus, he could have done the needful for providing that Kabinnama and the marriage certificate were false and forged document. But he has not been able to do so. Further, he has stated in his evidence that his signatures were forcibly obtained on blank papers. But the Kabinnama filed by the first party in his case is not prepared on blank papers, but it is a government printed form. Furthermore, the marriage certificate filed by the first party bears a clear joint photograph of both side parties. It may also be mentioned here that if the claim of the second party regarding the alleged incident dated 26 were true, in that event, he would have approached the police against the aforesaid misdeed of the first party. In his cross-examination, he has admitted that he did not lodge any case against the first party for forceful obtaining his signature on Kabinnama. The very fact that he did not approach the police raises the question of aforesaid claim of the second party. In view of the above discussion, it gets established from the evidence of the touchstone of preponderance of the probability that the first party is the wife of the second party. Point number one is accordingly decided in affirmative. It is claimed that first party that she does not have any income of her own. In her cross-examination done on 18/11/24, the first party as PW1 denied the defense suggestion that at present she is working as Mohori in the Bolpata court premises earning ₹2,000 per day. Further, in his evidence on second party stated that first party claiming himself as a Mohori used to roam here and there in the court premises of Bolpata court doing miscellaneous work. But the second party has not established the above fact that the first party worked as Mohori in the Bolpata court premises by adducing relevant evidence in this case. In that view of the matter, it is held that the first party is unable to maintain herself. Point number two is accordingly decided affirmative and favor of the first party. First party asserted her evidence in the second party is the computer operator working as Bolpata and has landed properties. The second party, the one stated in his cross-examination that presently he is working as a DTP shop of the Abu Bakr Siddiq, situated at the court premises Bolpata, and earns 4,500 per month from the said work. However, his affidavit of assets and liabilities, he declared his income is nil. It may be mentioned here that the income of a person is something within which special knowledge, and therefore, in view of the section 106 of the Evidence Act, the burden of the proof is only on that person to prove his income. But in this case, the second party, apart from examining himself, has not proved his income by adducing relevant evidence in that regard. It is well settled that where the husband is healthy, able-bodied, and is in the position of maintain himself, he is legally obliged to maintain his wife and his minor children as well. From the evidence presented in the case, it gets established on the touchstone of the preponderance of the probabilities that the second party is well qualified, able-bodied, and is having sufficient means to maintain himself. Therefore, he is deemed to be having sufficient means to maintain the first party as well. Hence, the first point number 3 is decided affirmative in favor of the first party. On the strength of the testimony of the first party, due to the effect that marrying her in the year 19 by executing Kabinnama, the second party lived in her father's house for about 5 months and then took her to his own house. But after marrying another lady named Abida Khatun, and subsequently he along with Abida Khatun started torturing her and unlawful demands, and eventually he drove her out of his house as she could not meet those demands. It gets established on the touchstone of the preponderance of the probabilities that the second party tortured and neglected her during her stay with him, and that after her expulsion from his house, he has been neglecting her and not providing any maintenance to her despite having sufficient means. The only claim of the second party in this case is that first party is not his wife and that he never cohabited with her as her husband, but he has not been able to probabilize his said claim. It has already been held as per the point number 1 above that first party is the wife. Therefore, the point number 4 is decided affirmative. In the light of the discussion made above, first party is entitled to receive monthly maintenance allowances from second party. Being the husband of the first party, the second party is legally and morally obliged to maintain her, ensuring her well-being and protecting her from the falling into the poverty and destitution. Considering the overall facts and circumstances of the case, current cost of living and reasonable financial needs of the first party, monthly maintenance of ₹3,000 for the first party appears to be just, adequate, and reasonable to meet the ends of justice in the case. The first party is entitled to receive same from second party. In the order, the second party shall pay maintenance allowances to the first month with effect from 17/11/21. My lord, this order was under challenge that I have already submitted before your lordship at the very outset that she has sworn an affidavit, my lord, only claiming that I am only divorced from the first husband, which cannot absolve her from the responsibility to file a regular divorce as the civil suit for dissolution of the marriage in the civil court, my lord. That is the requirement of the Shariat Act. Then my lord, everyone I can go and tomorrow and sworn an affidavit and I have given up my first wife, I will now marry.
But that's okay. But
Another thing, my lord, your lordship, I think I don't know whether your lordship is casual or that is, my lord, what happened? This liability certificate regarding income of the wife was not given. That is required, as your lordship now decided 2 cases on the same point.
that is,
Wife has not submitted any.
law is still not that it will be, the order will be illegal, but it is necessary. It is otherwise necessary.
Yes.
3,000 per month. He is actually the Learned Family Court relied upon these documents submitted by her.
Subsequent document regarding marriage,
Kabindama and all that.
all these things. But my lord, if
And
your
shifted
lordship,
and held that the burden shifted to the petitioner.
Yes.
Which he could not.
He could not do it.
According to the family.
and moreover,
So
the
it-
Kaji was also not examined. What was the wrong to being the Kaji? When Kaji has conducted the so-called marriage? My lord, if your lordship don't interfere in this case, then what happened? Every Muslim Shariat Act will be changed. Then yes, by swearing an affidavit, one can get married, which will be very detrimental to the society against the established law. That's why your lordship interference is required. So I pray that my lord, the order may be set aside and he may be absolved from the responsibility of paying maintenance. This is my submission, my lord.
I'll come to you, just a minute.
Yes. Yes.
This divorce affidavit which he has mentioned, is it there?
Yes. In our evidence, she said that.
In the record, is it there?
Affidavit is there. In our petition also we have filed, my lord.
No, not petition. Okay.
Yes, I'm giving, my lord. Of course, in her evidence, she stated that by swearing an affidavit. This is the same affidavit we have collected.
She has filed a photocopy.
Yes,
Here is
she
it.
filed a photocopy, yes.
Photocopy of the divorce affidavit. No, I felt that I did not get legally.
And that was also not proved with the original.
But I'm, it's not available in the record, it seems. This affidavit If it was in the record.
Record has
that's
come, my
very
lord.
helpful.
Any.
You want to have a look? Kindly have a look, the record. I did not find it. Exhibited,
He's also has the same copy.
documents exhibited by first party names.
Lordship, I have also a copy of that.
You-
That-
So it's not
Yes.
disputed.
But it was not in the record.
No exhibited, it's not exhibited,
Not exhibited.
not exhibited.
Not
But
exhibited.
anyway. Should I start your argument?
Yes, Lordship. May.
Give
Lordship,
me half a minute, I'll just. No. Okay.
Lordship, the petitioner once married with another person. After giving divorce to him, petitioner married this, respondent married this petitioner, Lordship, Tafazul Hussain.
One thing I just want to, take your help, that she has mentioned about, at that time which it existed, triple talaq. She has mentioned about that, and I have also accepted the same. One Abdul Manik Ahmed, this is the same person, Manik Ali,
Yes.
and thereafter, I decided to divorce my husband at my own will. Because this I have not understood fully. I mean, maybe I will to better throw light, because she says that he resorted to this irrevocable triple talaq, and then she accepted, and thereafter she divorced. But in the cross examination, she has said that he did not divorce her. He divorced.
She divorced.
He divorced him.
Hmm.
Anyway. So this aspect remains hazy. Anyway,
Lordship,
so the next, what should I take up?
as per Sharia, Muslim Sharia Act.
No,
Muslim
yeah.
Sharia.
Okay.
Khula has given to the women to divorce husband. If husband did not properly maintain his wife, physical and sexually assaults, then wife can divorce husband, but by way of public, and that should be in public. It is notary, this affidavit is in public domain, Lordship, by way of khula, Lordship. It is in the Muslim Sharia law. After divorce his first husband, she married this Tafazul Hussain petitioner, Lordship, and after solemnizing, by way of executing a kabidnama, and in the, PW2 deposed before the trial court, his signature also in the kabidnama, and he deposed before the trial court, Lordship, saying that this person, Tafazul Hussain petitioner, married Fulmala Khatun, respondent, Lordship, by way of customary law and executing a kabidnama. So the marriage is proved. And here the respondent in his Lordship, DW1 may go to the deposition, Lordship, evidence of PWs and DW. DW1. May I, Lordship, read? May I read, Lordship? DW1.
Yes.
I have been knowing the first party since the year 2017. I didn't lodge any case against the first party for forcefully obtaining my signature on Kabinnama. If his signature was taken forcefully, then he could complain it, Lordship, before magistrate or police.
True, but the thing is that
It is number 3. It is not a fact that I have deposed falsely that the first party for forcefully obtaining my signature on Kabinnama. Presently, I am working in a DTP shop. He previously stated that petitioner previously stated that he has no any income, but here it is said that I am working in a DTP shop of one Abu Bakr Siddiq situated at court premises, Borbeta. I earn rupees 4,000 to rupees 4,500 per month from the said work. It is not a fact that I earn about rupees 50,000 per month from DTP work and also from my landed property. He has also landed property, Lordship. So he stated that it is what he has said. These are not false statements. Marriage happened, Lordship. Marriage took place. And after marriage, the petitioner stayed with her legally married wife in her father's house, Lordship, in her paternal house. After one day, he came from her house to his live with his mother parents, and subsequently his wife also came to the petitioner's house. After coming to the husband's house, she was brutally assaulted by mentally and physically. Petitioner demanded rupees 2 lakh for as dowry money, Lordship, and he snatched her belongings, Lordship, and drove her out from her matrimonial home. So all the points clearly shows that she was a legally married wife, though she was married earlier. She divorced her first husband, and after divorcing her first husband, she married with this person. She is now economically weak, Lordship.
that Kabinnama is on record. This exhibit. That was.
It could be, Lordship.
Nothing was exhibited actually. But how did in the impugned order, there is a reference to that Kabinnama, right? But there was nothing not proved from the side of this thing, from the side of the first party.
There is a marriage certificate with the Kabinnama, Lordship.
Whether it was exhibited or not.
I don't know. There was it was not exhibited.
Unless you exhibited, you'll go back again.
It was not exhibited. But the learned court below referred to the joint photograph.
Interesting, that is that.
How come? Some procedure, but still.
Yes, there is a lapse in the procedural aspect also, my lord.
See, the thing is that as I understand, you correct me if I am wrong, that as I understand is that in maintenance matters under 125, strict proof of marriage is not necessary. Okay, strict proof of marriage is not necessary. Marriage has to be proved broadly, but here the situation is slightly different. It's an admitted position on her part that she was married to someone, right?
Manikani, yes.
She was admitted to she was married to someone, a person.
Divorce also.
Manikani.
Yes.
Yeah, so she has to give reasonable evidence, in my humble opinion, that she has divorced. So with regard to that, we do not have any document. This, as Lord Counsel has said, affidavit may not be sufficient. It has not been exhibited also. Affidavit is not evidence also, but it has not been exhibited also. And in the cross-examinations, he has stated that he did not divorce me, I divorced him, right?
Yes.
I divorced Manipan. But here she also talks about this triple talaq. So isn't the evidence regarding the dissolution of that marriage inadequate or even non-existent? In which case, if it is not, since it's an admitted position that she was married to this person, therefore there has to be some, she can be given maintenance only when there is material to show that that marriage has been dissolved.
Correct.
And if there is no material, then that could come in the way.
Lordship, that affidavit.
You
is
may
also
correct
with
me.
Senior and
If I
with
thought
me.
wrongly, you may correct me. That's why I'm discussing, because without, if I write it, yes. So the none, because, let me go back to, because we have some time constraint also. The judgment he has referred to a joint photograph.
Yes, in the
The
judgment.
learned
also-
found filed certain documents. What the documents show a registration number of the marriage.
Also, the registration number also given.
Name of PW2. Bride's will.
What should be the judgment and order, point number 8.
This was not exhibited, right?
Not exhibited.
But can you go back to page 19 of your petition?
Yes, I am reading merit.
Because first you have to negotiate with
Yes.
aspect.
First party has signed this Kabinnama. Furthermore, the first party has filed certain documents in this case. Where is those documents, merit? Why not
Including
exhibited?
Kavinnama and marriage certificate.
Yes, including the Kabinnama and marriage certificate. Both the documents show registration number of Sat and Sat and dated 31/1/19. The name of PW2 appears to Kabinnama as bride's ukil. On the other hand, second party on whom the onus lays to disprove the factum of the marriage has not been able to discharge the said onus. He could have done the needful for providing that the Kabinnama and the marriage certificate were
These
false.
documents, just submitting the documents, will it do?
Yes.
Just submitting the documents before the court, will it do? Don't you think those the documents have to be reasonably proved?
Exactly.
Exhibited?
Have to be.
Even if the strict standards of evidence act are not applicable.
Yes.
That we know.
Yes.
Summary procedure, but
Yes.
still, but
I do not know why learned court below has not
in
taken up
cross
this
CS,
matter.
cross CS said also that original is with me.
Yeah.
I've submitted the photocopy. That will be,
And those are not exhibited. That is the reason. How court have taken the consideration those things matter.
time of receipt, this appears to be a genuine document along with this, but photocopy is
Photo-
not exhibited.
Yes,
We do
yes.
not know
No.
this one. This one you have only given.
Yes, my.
So I think that's all. Anything else you want to submit?
Lordship, then Lordship, in the final order, the Kabinnama and the marriage certificate state that, Lordship.
The number of.
It has stated.
Court has
yes.
also said that. There is a
Mhm.
number, court has taken the considered number, but why, what is the document?
From where,
Document was not exhibited.
from where the
It
court
was submitted.
can
So it
And
state
we,
this.
we do not even know whether it was submitted in original.
Oh,
or photocopy.
exactly.
Do not know.
That is the problem.
That may not be efficient. This is the difficulty. Hold on, if you don't. So, resolve the. You can go for the mentions, I think. Waste the time. I'll close it.
Yes, ma'am.
I'll reserve it.
Yes,
There's no time to dictate.
Yes, ma'am.
Can I keep this for the moment?
Yes, your lordship.
Yes.
Your side also. You have a copy of this?
Lordship, I want that copy, Lordship.
I'll read a photocopy for you.
Photocopy the Lordship.
I'll
Not.
make a photocopy and return it to you. Oh. It's petitioner side.
Lordship, one thing, by way of Khula,
Yes.
KHUL, Khula,
Mm.
Muslim women can divorce her husband, Lordship. If she severely, mentally and physically abused.
Khula, do you
Khula.
want to show something?
At present, I have nothing, Lordship.
As I said,
Khula.
Muslim law, it's not easy. It has
So
its
it is
complexities.
public also.
It has its
It's
complexities.
Public also.
Mm.
So
And-
the affidavit is in public, Lordship. It's a public.
Cannot be in public.
No, it's a public document, Lordship.
Public document, but it is not in public. Public is something different.
Then it will involve us going into this complexities of this, what is the scope of a khula? We'll have to go into that. Is it-
Published.
You can go for mention, I think. Yes. There will not be time. Hearing matters to it's
Item number 46.
Mhm.
It's an IA pending.
Yes.
But can it be fixed on Thursday?
Okay. What is the length of the?
My lord, he 10 years,
10
already he's been in custody for 600 plus days.
This thing, prosecution.
I'm for the informant also. I'm appealing for the informant. I'm appointed as amicus, my lord.
Amicus. You have filed an objection. We already filed. Let it be after vacation. That will be best. After vacation.
Some urgencies there, my lord. Possible.
Because otherwise, you may not be able to take it also. So there will be so many matters on Thursday. Let it be immediately on reopen on 19th. Our conviction under what section? What section?
376. 376.
After vacation, 19th. No, we'll take it down on 19th or 20. That will be better. 20. No, 20.
Obliged.
Item 1011, my lord. Date may be fixed, my lord. My lord. Wait for a date, my lord.
25 matter. When should I fix it? Last week of January or first week of
Any-
February?
The
First week
next date before the trial court is 17/2, my lord. Any date before that, my lord.
First week of February. First week of February. First week of February on a date to be fixed by the registry, 10 and 11.
My lord.
Paucity of time. until
pleasure.
full by the registry.
Right, items number 51, 52, and 53, my lord.
Mm.
The lordship would remember that appeal, my lord, where we had taken the 313 plea, my lord.
Mm.
On the last occasion, your lordship was pleased to direct for the preparation of a paper book that has been prepared.
Prepared.
We are prepared, my lord. So may I pray, my lord, on 17th of February, my lord, is agreeable to all the appellants, my lord.
Item number?
51, 52, and 53, my lord.
53. Yes. Okay, 17th February, 17th.
17th. My lord, one more prayer. On the earlier occasions, your lordship had fixed it at 2. So on 17th at 2, my lord, if possible.
Let it be, you can come in normal course only.
I'm deeply obliged.
We'll see. 23 matter. 17 to.
Item number 48,
The interim order is still today. That may be extended.
48?
Yes.
No problem. Paucity of time, interim order stands extended in the next day. List, list after the view petition on a date to be fixed by the registrar.
May I
Highly
please-
obliged.
May I please, item 13, Lordship, interim is there, may we continue?
30,
13, 1-3.
1-3. Interim order, 1-3, interim order till next day. List after view holidays on a date to be fixed by the registrar.
Of that.
Then it is better. That's all. That's it.